safety, and welfare by establishing and maintaining standards of excellence used in regulating the practice of medicine, and ensuring quality health care for the citizens of Texas through licensure, discipline, and education. That is the mission of the Texas Medical Board. With that, we'll go ahead and start the meeting. I'm going to ask Mr. Carlton to go ahead and call to order and have a roll call.
Yes, good morning, everyone. Dr. Zaffron.
Present.
Dr. Farmer.
Present.
Mr. Kokonos.
Present.
Mrs. Barnes.
Here.
Dr. Bhatia.
Present.
Dr. Deloche.
Here.
Dr. DeStefano. Mr. Gracia.
Present.
Mrs. Harrod.
I'm here.
Dr. Martinez.
Here.
Mrs. Morgan.
Here.
Dr. Naidu. Dr. Nyack.
Present.
Dr. Quinones.
Present.
Dr. Tibbles.
Here.
Dr. Vanderwide.
Yes, sir.
All right, we have a quorum and may proceed.
Great, thank you. First item on the agenda is a board member report. There's a couple of items I'm just going to highlight. As all of you know, we have a fingerprinting process that has been in place for the last couple of months as a result of previous legislation to fingerprint all new renewing licensees over the next couple of years. To date, over 8,300 physicians have successfully completed this requirement. We're asking all of our licensees to please continue being patient if reaching out to the Texas Medical Board about obtaining your 6-digit ID and the Texas Medical Board service code required for fingerprinting. Staff across all areas of the registration department are working very hard to answer those inquiries as timely as possible, while also still managing their normal responsibilities, with many of them working overtime to respond to fingerprinting inquiries alone. I understand that there's a lot of concern and heartburn when you may have only 1 week left on your license renewal and you're just starting that process. I would encourage all of our licensees to know that you can start the fingerprinting process as early as you want. It could even be a year before your license renewal. And once that process is done, you won't have to repeat it when you actually have to renew your license. So it just helps to kind of try to do that ahead of time and not wait until the last minute. Also, we have a CE broker launch. Texas Medical Board is preparing to partner with a company called CE Broker, which is a continuing education compliance system later this year. The goal of this partnership is to help licensees find, track, and report continuing education to the board, and will subsequently allow the board to further streamline the renewal process. This will be a free and optional service for licensees. It will be rolled out to different TMB license types in phases over the next year, beginning this June with our physician licensees and then to the other licensees afterward. Our licensees will receive detailed communication about the service as we get closer to June. The other thing is the Federation of State Medical Boards is an entity that all medical boards in the country partner with, including the Texas Medical Board. We are continuing to increase our influence with the Federation of State Medical Boards, increasing our partnership with them. Currently, I used to be the representative for the TMB to the FSMB. Currently, I'm actually on the board of directors of the FSMB, and Chris Balzola and Brent Carlton are serving as the representatives from the TMB also. We're fully utilizing the scholarships that the FSMB offers to increase our influence, and it's primarily to make sure that we are able to showcase the Texas influence and some of the things that we've done in the Texas Medical Board for our licensees, at least at the national level. The other issue that has been also percolating over the last couple of years, we've heard a little bit about the ketamine and the hydration clinics. This is going to continue being an area of oversight that we will continue to look over. I have mentioned before that ketamine clinics will be looked at as of right now, as of following the OBA rules, office-based anesthesia rules, if you're going to be operating a ketamine clinic. We consider ketamine to be an anesthetic agent as it's defined by the FDA. And as such, if it's being used in facilities outside of hospitals, we feel that it should be following office-based anesthesia types of rules. Finally, I'm just going to briefly go over some rulemaking that we're going to be doing later today. I'm sure all of you are here to listen to the first part and not this part. But I'm just going to kind of highlight how this process is going to work later on. As all of you know, the Texas Medical Board is proposing amendments to 22 TAC 165 by adding subchapter B, new rule, section 165.7 through 165.9 concerning exceptions to the abortion ban. The proposed rules have been published on the board's website at the following link. We can put that out there for everyone. The public may submit written comments on the proposed rule using a web form link that will be on the site. The proposed rules do not regulate or prohibit abortion, but are being promulgated to clarify the regulatory analysis to be utilized by the Texas Medical Board for our licensees. The rules are drafted, or as drafted, reaffirm that when investigating any complaint, it will be conducted consistent with the standard processes and disciplinary authority that applies to all complaints and investigations. Two other things that I will highlight, and I will say this later on in the meeting when we start looking at the proposed rule, is that as there is pending litigation around this issue, the Attorney General's office was consulted on this issue prior to rule language consideration. Also, the thing that I would also reiterate is the language that was put in the Texas Supreme Court ruling, which states that a woman who meets the medical necessity exception need not seek a court order to obtain an abortion. Under the law, it is a doctor who must decide that a woman is suffering from a life-threatening condition during a pregnancy, raising the necessity for an abortion to save her life or to prevent impairment of a major bodily function. The law leaves to physicians, not judges, both the discretion and the responsibility to exercise their reasonable medical judgment given the unique facts and circumstances of each patient. And as you will see later today, the way the rule will be presented is to, number one, help define what some of those definitions are that are already existing in the code, as well as the process of which we will consider a complaint if it comes to us as a medical board as we look at physician judgment, and also a directive to physicians on how to document, and also looking at medical necessity, just like we would with any other case that's out there. So when we look for guidance, a lot of it is more about process also, and what we feel that physicians should be doing as they consider exceptions as we are defining it in law. So there will be more to come on that later on. There is a larger statement that will be released to the press later on also, so you'll be able to have that. And again, I will kind of go over this again as we get to that part of the rulemaking a little bit later on in the day. Just so that all of you know, we're going to be going through the entire agenda of the medical board first. There's a whole process to that, including listening to some cases that involves physicians specifically. Those sometimes take a little bit of time. When we go into executive session, which is when we start deliberating the issue itself, typically speaking, all of you would exit, but we're not going to do that today. We as a medical board will exit the room and go into executive session. And then as we finish our executive session, we will come back and start the meeting over again. At the end of the meeting, and again, I'll try to expedite most of this until we get to the rulemaking process, we will lay out what the rule looks like. We will read it out. We will debate it amongst the board members ourselves. We'll be able to ask some questions, and then we will consider what it looks like as far as putting it out or as far as approving it as is or with amendments, or possibly even not approving it at all. Once that happens, if there's an approval, the process will continue afterwards in a 30-day period of a comment period where the public and other stakeholders can actually provide comment. There may be a stakeholder meeting that we will announce at some point, also to allow for some more input. Those will all be announced at later dates. Toward the end of the meeting, we will also open the board for public comment. We do that for every single meeting. I'm sure that today most of the comment will be about one specific issue, but our intent is to allow everyone to speak. We give everyone 3 minutes. This is not a dialogue between the board and the public. It's an opportunity for the public to make comments, again, with that 3-minute limit, and be able to provide that input to the medical board. But again, we'll go through that process a little bit later on in the day. All right, with that, I'll go ahead and proceed on with the order of business. Next item on the agenda is consideration and possible action for dispositions below minimum guidelines. We have 5 items on the agenda. Is there any extractions on the items of the agenda?
Any recusals?
Is there any recusals? Seeing none, is there a motion for approval of item number 3, which is consideration and possible action for dispositions below?
Motion for approval. Dr. Quinones.
Second, Bond.
There's been a motion and it's been seconded. Is there any further debate? All those in favor, please say aye.
Aye.
All those
Aye.
opposed? Motion passes. Next item on the agenda is consideration and approval of mediated settlement agreed orders. There are several items under this, including, actually, there's only one item on this agenda. Is there any extractions or recusals on this item?
Dr. Quinones recusal on item number 2.
Okay, Dr. Quinones is
Sorry.
recused.
Excuse me.
Which
We're
one is
still
it?
on 4, only has the
Oh, we're still
one.
on 4.
5 will be.
Yeah,
the
okay.
I
next
think you're in
one.
5.
Yeah.
Yeah, 4 is just that one item.
4.
So any recusals on item number 4?
Yes. Dr. Quinones, oh, excuse me, not on item number 4.
Okay, all right. So seeing none, is there a motion on agenda item number 4?
Move to approve.
Second, Vanderwine.
Okay, there's been a motion, it's been seconded. Is there any further discussion? All those in favor, please say aye.
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 All those opposed?
All right. One piece of housekeeping for us. Dr. Naidu was able to sign on at 8:20. So just want to get that into our record also.
Okay.
All right.
All right, agenda item number 5, and there's several sub items here. Consideration and possible action for remedial plans. We have administrative rules, crime laws, impairment none, peer review state action none. We do have items under standard of care, unprofessional conduct, and late remedial plans. So under agenda item number 5, are there any extractions or recusals?
Dr. Quinones extraction, recusal, item number 2,
Okay,
item number 25, and item number 39.
all right. Dr. Quinones is recused from item number 2, item number 25, and item number 39. Any additional recusals?
I've got a recusal, Dr. Tibble's under administrative rules, item number 3.
Okay, Dr. Tibbles is recusing from item number 3. Any additional recusals? Any extractions? All right, seeing none, is there a motion on agenda item number 5?
So move, Harrod.
Second, Vanderwine.
All right, there's been a motion, it's been seconded. So with the exception of the recusals on 2, 3, 25, and 39, is there any discussion on this? All those in favor, please say aye.
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 All those opposed? Agenda item number 5 passes. Number 6, consideration and possible action for agreed orders. We have impairment, peer review state action, standard of care, unprofessional conduct, and late orders. Are there any recusals or extractions on agenda item number 6?
Dr. Bhatia, impairment number 3.
Dr. Bhatia is recusing from number 3. Any other additional recusals? Any extractions? All right, is there a motion on agenda item number 6? Moved by Dr. Farmer, is there a second?
Second, Martinez.
Seconded by Martinez. Is there any further discussion? With the exception of the recusal for number 3 for Dr. Bhatia, all those in favor, please say aye.
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 All those opposed? Agenda item number 6 passes. Number 7, consideration and approval of modification request, termination request orders. There are 6 items under this agenda. Are there any extractions or recusals? Seeing none, is there a motion on agenda item number 7?
A motion, Poconos, consideration approve modification request, termination request orders.
Second, Bar.
There's been a motion, it's been seconded. Is there any further discussion? All those in favor, please say aye.
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 All those opposed? Motion passes. Agenda item number 8, consideration and approval of modification request, termination request of non-public rehabilitation orders. There's no items there. Number 9, consideration and approval of cease and desist orders. There are 16 items there. Is there any extractions or recusals on agenda item number 9? Seeing none, is there a motion on agenda item number 9?
Move to approve, Bhatia.
Second, Morgan.
Motion to approve and seconded. Is there any further discussion? Seeing none, all those in favor, please say aye.
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 All those opposed? Agenda item number 9 passes. All right, agenda item number 10, 11, 12, and 13. There are no items there, which brings us to agenda item number 14, which is consideration and approval of proposal for decision. The First item on here is Dr. Fadi George Ghanem, MD, SOA docket number 503-22-09544. Do we have staff, and is the physician here? All right, can staff come up to present, please?
Yes, Dr. Zafran, Shane Neldner will be presenting virtually for staff.
Okay.
And it's our understanding that Dr. Ghanem and his counsel, if they're appearing, will be appearing virtually as well.
All right, are they here virtually?
Let's take a look.
Doctor, are you with us?
Hello, I can confirm, this is Shane Neldner with the Litigation Division. I can confirm that opposing counsel is available in the waiting room, just waiting to see if he'll be let in.
Okay. Alicia? can you-
Yes, I'm looking. There's about 200 people on the list. So.
Yeah,
Okay.
it'd be Dan Leip.
Thank you. Okay, Mr. Lipe, you should have camera access now.
Yes, thank you.
Hi, good morning, Counselor. Is Dr. Ghanem here also?
Yeah, he should be signed on as well.
All right. Alicia, can you?
He may be in the waiting room though. I'm not
Yeah.
sure.
Also has mic and camera access now.
Okay, great. Dr. Ghanem, can you hear us? Dr. Ghanem?
I'm here.
Hi, good morning.
Good morning.
Okay, I think everyone is here. Typically how we do this is staff will go first. They have a total of 10 minutes to make a statement and then reserve any time left for a rebuttal. And then Mr. Ghanem and his counsel will go second. So I think we're ready to begin.
All right. Thank you, board members. I'd like to reserve the remainder of my time for rebuttal. Shane Neldner with the Litigation Department. In August 2022, respondent was convicted by a jury of his peers of a third-degree felony practicing medicine in violation of the Texas Medical Practice Act for operating an unregistered pain management clinic. During his criminal trial, respondent's counsel argued that because he would no longer be practicing medicine, he should be given leniency in sentencing. That is, he should not face incarceration. That argument worked, and the judge sentenced him to 10 years of imprisonment, but suspended the sentence and instead ordered 7 years of community service. After his conviction, board staff filed a SOA complaint related to his criminal violations, and board staff won a motion for summary disposition, which resolved all of the factual allegations in the board's favor, and a hearing on aggravating and mitigating factors only was held on September 11th, 2023. As a result of that, the ALJ found the following aggravating factors present: 1 or more violations that involve more than one patient, increased potential of harm to the public, intentional, premeditated, knowing, or grossly negligent acts constituting a violation, previous disciplinary action by the board, and other relevant circumstances increasing the seriousness of the conduct. And it was specified respondent's representation to the criminal court judge that he would no longer be practicing medicine. Now, with his freedom from incarceration secured, respondent argued at SOA for several mitigating factors, which were calculated to allow him to return to practice. Respondent is here today to present a case that he should be allowed to return to practice. And to justify this, respondent would ask the board to set aside his assurances to the criminal court that he wouldn't be returning to practice, to set aside his board history, including the finding that his continuation in practice posed a continuing threat to the public welfare, set aside his criminal conviction, and set aside the criminal judge's observations of respondent at that trial, namely that respondent was very aware of the public scrutiny that comes with registering a PMC, that respondent demonstrated his hostility toward PMC regulations, and that respondent didn't get a PMC certificate deliberately because respondent thinks he knows better than everybody else. Now, nothing about respondents' attitude on these issues have changed since the criminal court judge made these observations. He continues to deny that he did nothing wrong by not registering his PMC. Now, board staff would ask the board to note that when his former clinic administrator expressed her concern that 80% of their patients were prescribed controlled substances, and he responded, quote, or paraphrased, if they stopped seeing patients who sought controlled substances, they would have very few patients. And pay special attention to the fact that respondent assured the court that he wouldn't be practicing medicine in order to avoid time behind bars. But now respondent and his counsel are going to come and tell you why he should be allowed to return to the practice of medicine. Board staff is unpersuaded that respondent has learned any lesson, and board staff is not persuaded that respondent can return to practice because he's currently temporarily suspended without posing a continuing threat to the public welfare. And for these reasons, board staff recommends that the board revoke respondent's medical license. Thank you.
All right, thank you. Dr. Ghanem, Mr. Leip, your turn.
Yes. Thank you for meeting with us today. We requested a SOA hearing. The issue as far as Dr. Ghanem's conviction, that is settled. We did not oppose summary disposition on that grounds. The sole purpose of the hearing was a hearing on aggravating and mitigating factors for the judge to, look at evidence, present findings on that. So when we appeared before you today, that there is a record on that. Dr. Ghanem's conviction, it is under appeal. It's probably going to be a while before there's a resolution on that, but that's kind of set to the side today because right now he is convicted. I do want to address staff's has put a lot of emphasis on Dr. Ghanem claiming he's not going to practice anymore and getting leniency and not having to do time because of that, and yet now he is asking for the ability to return to practice. His criminal attorney did note during the sentencing hearing that he's not going to practice medicine anymore. And the judge, though, after that, when he ruled, he made very clear that I'm going to put in this probation order that you can't practice medicine, but if you can come back to me later, particularly with any sort of guidance from the medical board, I will consider removing that and allowing you to return back to medicine. So it's not as cut and dry, I think, as staff is presenting. What we are asking for today is really pretty limited. Would be basically a probated revocation, not allowed to have any prescribing or authority regarding controlled substances, not able to practice pain management. Really all Dr. Ghanem would love the chance to do at this point, kind of with the end of his career, is to do volunteer work, both with an organization in the Houston area he founded and has some continuing ties with, called 100 Hands Alliance, with the judge did enter some findings on. And also he has ties with Lebanon. That's where he immigrated from. And his wife has ties with, I believe it is, Indonesia. And he would like to have kind of an opportunity to do some volunteer work there as a physician, and really can't do that without having a medical license somewhere. But, what we're asking for is a very restrictive order that would really just allow him to do that. And then also he has a background in some traditional holistic medicine as well, particularly Chinese Qigong and herbal remedies and other things like that, acupuncture, that he would like to be able to offer as well. But really, he's just asking for a chance to do that with the rest of his career. He obviously doesn't want to return to pain management or even necessarily full primary practice anymore. The judge did enter findings that Dr. Ghanem does have rehabilitative potential and does have current value to the community because of his past volunteer work and what he wants to do at this point. But with that, Dr. Ghanem, is there anything you would like to say or add to that?
No, I just want to thank the board for their consideration. And I don't want to rebut the board council characterization that I voluntarily chose to not follow the board rules. I followed them based on my clinical judgment and understanding at the time regarding what it meant. I practiced based on my years of experience and training. I was board certified and recertified 3 times in family medicine. I followed the modules that we had in our training, how to treat patients with chronic pain based on my specialty and based on what was present at the time on the TMB website in terms of guidance that I understood it. I took additional training and certification in traditional Chinese medicine, both acupuncture. I'm certified in acupuncture and Chinese herbal remedies since 2016, and I use that with my patients as well. And I thought treating their basic medical problem in addition to their chronic illness would help alleviate their pain, as well as meet the criteria that was present at the time on the TMB website. But it seems this has to be clarified, and that's why I chose to appeal this, because this would be of value both to our profession in general, to family medicine, and to the board as well, that these rules, once clarified, they will be of use to all of us, where litigation intersects with the clinical decision making. And I hope I would come back someday in the future to the board and present the result of my appeal that would be useful to our profession and to really the clarification of these occupational codes that would benefit from what I'm going through. And that's all I have to say, and I appreciate your consideration. And whatever your decision is, I will have to live with it for the time being. And I hope we can intersect and meet again. Thank you.
The final thing I'll say.
No further comments. Thank you.
The final thing I'll say is just getting back to his criminal case. Like I alluded to earlier, the court right now, he's not allowed to practice medicine as part of his probationary settings. But like I said earlier, the judge has made clear that he can come back later, particularly if there's any guidance from the medical board in the form of, a board order that would potentially allow him to practice medicine, that he would reconsider that and potentially allow Dr. Ghanem to, return to some sort of limited practice pursuant to board guidance. And that's essentially what we're pleading for today, is an order that would allow him to practice in some limited fashion for volunteer work, potentially doing volunteer work abroad even, if that was allowed by his probation. And, so he can present that to the criminal court and try and get that established. But with that, we'll go ahead and waive the rest of our time.
Thank you.
Thank you, Counselor. Shane? You may proceed.
Thank you, sir. Just to respond to some of the things that were said, those words, the observations that respondent was very aware of the public scrutiny, those aren't my words. Those aren't characterizations that I have made up. Those were observations made by the criminal court judge who observed respondent at a criminal trial for several days, observed his testimony and his conduct in the courtroom, and observed that he was aware of what was required of him. He had an attitude that the PMC regulations were restrictive, came with additional scrutiny, and that he knew better than everybody else. That wasn't my observation. Okay, I want to make that clear. Further, the observation that, or the finding by the ALJ of the aggravating factor that of other relevant circumstances increasing the seriousness of the misconduct. That is, again, not my finding. That is the ALJ's finding. And the ALJ specifically noted in that finding, in the proposal for decision, quote, that is respondent's assurance that he would no longer practice medicine during the sentencing portion of the criminal trial. That's set in stone by the ALJ, not me. And so I want to make sure that the board understands that. I would say that respondent has been out of practice since November 4th, 2019. So there is an active practice issue. And as far as respondent's ability to volunteer, both in the United States and in other places, he's free to do that. But board staff would maintain that his volunteering as a doctor, given the circumstances, given the factual findings, both of his criminal trial and of the SOA proceeding, that allowing him to return to practice now after all this time and considering the violations would be a continuing threat to the public welfare. And for that reason, board staff would ask the board to look at the final order that's been presented regarding a resolution of this matter and find revocation would be appropriate and adopt that final order. Thank you.
All right, thank you.
Thank you. I guess one of the questions I have, I mean, I understand that you were able to bring down your felony conviction and probate it, but that doesn't negate the underlying factors of why you were originally before the board and the fact that you were prescribing opioids and benzodiazepines to patients in a non-therapeutic type of matter. I'm a little concerned by your statement where you said that you were following TMB guidelines. Our guidelines are very specific as far as therapeutic prescribing and all the other types of testing and oversight and so forth that has to be done. And the other concern was the fact that you were prescribing to over 80% of your patients opioids and still having an unregistered pain management clinic. The guidelines and the rules are very clear that if you're prescribing to more than 50% of your patients, you have to have a registered pain management clinic so that there could be appropriate oversight. So again, I understand the criminal conviction, the felony and so forth, which makes it a straight revocation, but I don't want us to miss the fact that there were underlying issues even prior to that led to all these other things. So I don't know if any of the other board members have any questions as far as that's concerned, but I just don't want us to lose sight of the original underlying issue that was looked at with this case.
If I may respond, both counsel, is it okay if I respond?
Go ahead.
I really appreciate Dr. Zafar, is it?
Zafran.
Zafran, and I've followed your recommendations actually on the board website as well. And there was no opportunity for me to come back in front of the board and present any of the issues regarding patient care. There was at no point a decision from the board where I presented my case with the expert witnesses that I had that I did anything against what was the board rule, because every single patient I had, I saw them personally, clinically evaluated, examined, and treated their basic medical problem followed the guidelines of testing, of following the recommendation of the CDC and the board regarding what is appropriate, checked the PMP on every single patient and wrote it on their prescription with the diagnosis before the PMP requirement was even a mandate, after my issue was raised with in the Montgomery County. So, and I applied the other modalities that I trained as well to use in addition to treating their basic medical problem. In relation to the majority of the patient issue, I had 6,000 active patients in my practice. The 300 plus patients who came every month were required to come because I would not refill their medication without direct interaction because of the safety issue of these medications. But I always tried not to exceed the maximum that would be recommended for keeping the patient free of pain and active in their daily life while treating their basic medical problem and applying these modalities. So in terms of harm, there was not a single patient where I was found, whether by the DA or by the board, where I did not follow these safety guidelines, these safety rules. The issue was how the number of patients was counted in terms of a monthly basis, and I explained it here because they had to come every month, but the rest of my patients would come every 3 to 6 months for evaluation. And the other issue is the issue of the modalities applied, which was an issue that was not clear to me at the time, but I'm not going to make here excuses. I think in terms of the appeal and the process I'm going through, I think it would be truly helpful both to the board and to the profession at large to clarify it more for further consideration later on. Especially as a family doctor, if we restrict the role of a family doctor treating patients who present to us for any kind of pandemic or any of the major issues we deal with, we are at the forefront. I was at the forefront of these issues that are coming to us every day. And I try to find solutions that would provide safety and appropriate care for them. Now, I was found guilty because of the violation of the Texas Occupation Code, but in terms of the board ruling, I was put on suspension from the beginning because of the initiation of this violation that I was, when the DA arrested me back November 2019, and I haven't practiced since then. But this is the first time really I was able to come in front of your esteemed board and colleagues of mine, maybe, to be able to present it. But I don't want to take more of your time, and I will abide by whatever your decision respectfully. And I haven't practiced since 2019, and I respect your orders, whatever they may be. That's all I have to say. And God bless, and thank you for your time, and keep us in your prayers. Thank you.
Dr. Zafran, if I could respond.
Yeah, go ahead.
Go ahead.
Thank you. Respondent had the opportunity to present those kind of expert witnesses at his jury trial, at his criminal jury trial, and he did present these arguments to the criminal court regarding the nature of the care provided, and the court rejected it and found him guilty of that violation. And so to suggest that this is the very first time, now it is the first time perhaps in front of the board, but it's not the first time he's able to make this argument, and it was rejected at a jury trial. So I just wanted to point that out.
I guess the other question I would ask, Shane, is other than the inappropriate prescribing that he was found on, were there any other issues around harm to patients beyond the non-therapeutic prescribing?
So Dr. Zafran, if I can weigh in just from a procedural perspective on that, the board's complaint at the State Office of Administrative Hearings initially did include standard of care, PMC. It involved allegations of patient death related to prescribing of controlled substances. All of those things were in the initial SOA complaint. At the point that the jury convicted Dr. Ghanem, the board amended its complaint to narrow the case to the conviction for that felony. And at that point, the judge ruled for the board and there were no more factual issues at play. And so the next step in the trial at that point at SOA was to move on to aggravating and mitigating factors. And so the hearing at SOA was solely limited to aggravating and mitigating factors. In front of you today, you have a proposal for decision by the judge. It includes findings of fact and conclusions of law. The medical board legally does not have the authority to change a finding of fact or conclusion of law. Those findings of fact and conclusions of law include findings of aggravating factors and findings of mitigating factors. And so what's in front of you, board, today is to weigh the aggravating factors, weigh the mitigating factors, and decide what sanction is appropriate.
Amy, I understand.
Okay.
My question was big, though, as to were there other issues outside of therapeutic or non-therapeutic prescribing that were part of what was being looked at? It's just a very, basic question.
The case was about prescribing controlled substances to individual patients and also as a whole regarding whether or not he met the definition of a pain management clinic. Ultimately, he was convicted by a jury of a violation of the Medical Practice Act related to his PMC and related to his prescribing of controlled substances.
And if I can add in real quick, just to clarify that, the proceeding that went to the aggravating and mitigating factors hearing, as indicated by Ms. Swanholm, it didn't involve allegations of inappropriate prescribing. It was really that he had been convicted of not registering as a pain clinic when he should have registered. And that was the sole issue at his criminal trial too, was just whether he should register or not whether his prescribing was, from a standard of care perspective, appropriate or not.
Just thank you. And Shane, to clarify, he still has the felony conviction. It was the incarceration that was probated, correct?
I think Shane's
That's
having
correct.
a Teams issue. He'll be back in just one second.
That's right.
That
Amy
is
can't
correct,
answer
though.
for it. Yeah. Okay.
That is correct.
Yeah, and that actually is probably the most important thing here, because regardless of what we think, if there is still a felony conviction on the books, regardless of whether everything else has been mitigated, that does kind of limit what we as a board can do. So we will look at this and take everything under consideration. But regardless of all the facts out there, sometimes, we are limited by what we can do just based on what the law says we can do, depending on what kind of conviction you have that's out there. So again, we will discuss this unless there are any other questions by any of the board members.
Right. Does the board need to go into any type of executive session to discuss this at this time?
Can I ask a
Okay.
question?
Yeah.
Can I ask a question of the doctor?
Go ahead, Doctor. Go ahead, Dr. Quinones.
Dr. Ghanem, you said that you're board certified in family medicine. What status is that? What is the status of your certification right now?
I am not certified after 2019. I stopped practice and my certification expired by then.
So you're not board certified.
Not anymore, and I'm not practicing since 2019, November 2019.
Okay. Just for completeness, I think it would probably be appropriate that we go into executive session, because I think that there are some considerations of law that I think the board members should hear directly. And that way we can, render a judgment appropriately and at least make sure that we're putting out the explanation of why fully. So with that, does anybody want to make a motion to do? Motion's been
We
made.
go into executive session, Harriet.
We are
Second,
going to
Vanderwell.
go. Yeah, we'll figure out a way for you guys, but yes. Dr. Harrod was.
Yeah. You guys will you'll get pulled over just like in the other virtual ones. Just those of us here in the room will step out. Audience, you guys get to stay where you are if you'd like.
Okay, so the board may close the meeting to the public and continue an executive session for the following reasons. Deliberations concerning licensure applications and the character and fitness of applicants under the authority of the Medical Practice Act, sections 152.009, 155.058 Occupations Code. But in this case, it's private consultation and advice of counsel concerning pending or contemplated litigation settlement offers and legal matters subject to the attorney-client privilege under the authority of the Open Meetings Act, section 551.071 Government Code. While in executive session, the board will not take any action, make any decision, or vote with regard to any matter that may be considered or discussed. A certified agenda of any executive session will be made.
And there wasn't a second to vote on that, correct, Dr. Zafran?
There was a second by Mr. Kokonos.
All right. All in
Okay,
favor?
okay.
All in favor, please say aye.
All right.
All opposed?
Aye.
All right. So members of the public, we are going to exit the room for a short period of time. And when we come back, we will open up the meeting again and we'll proceed on from there.
The time is 9:00.
Okay. The executive session ended at 9:18 a.m. on March 22nd, 2024. There was no final action, decision, or vote with regard to any matter considered or discussed in executive session. A certified agenda of the executive session was made. Before we continue the discussion, I feel it's important to kind of explain the situation that we're in, Dr. Ganem, because this is a little bit nuanced, and I want you to understand the constraints we are in as far as the law is concerned. House Bill 1998 was passed in the last legislative session that talked very specifically about convictions, charges of felony and final convictions. When somebody's convicted or when somebody's charged with a felony, the board is not given any discretion but to suspend a license. And I understand, I'm sure you know the difference between suspending and revoking. And that license shall remain suspended until a final conviction where it will be revoked. And, you can also have a conviction, but there's also potentially all pending appeals that may be out there. So from that standpoint, if you do have a conviction and you're suspended, the board does have discretion to have a licensee suspended until there is a final conviction after all appeals, where at that point, the license would go from being suspended to revoked. The board has discretion to take a suspended license and under certain rules reactivate it. The board does not have discretion to take a revoked license unless there are certain conditions met, like an overturning of a conviction completely, but it's a little bit more of a complicated process to reissue a license. So that is the general process of how the law looks, and those are the constraints at which the board is at. So with that, I'm going to open up any discussion from the board members and with discussion or any potential motions.
Motion, please.
Dr. Quinones?
I make a motion. I move that the board adopt the findings of fact and conclusions of law as recommended by the administrative law judge in the proposal for a decision with the following change. I move that the respondent's license be suspended until all available appeal options are exhausted, and further direct staff that if a final conviction, if all appeals are overturned and there's a final conviction, that we move on to revocation.
Okay, thank you. Sorry, so to clarify, your motion is that the board will adopt the findings of fact, conclusions of law as recommended by the ALJ in the PFD, and also that the board is approving the final order. However, instead of an order of revocation, it's an order that the licensee remains suspended until such time that all appeals are exhausted. And if there is a final conviction, the license would be automatically revoked.
That is correct.
Okay.
Second, Vanderwijk.
I'll second it.
Seconded by Dr. Van Wyt and Dr. Bhatia. Is there any discussion on that motion? All right, all those in favor, please say aye.
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 All those opposed? All right, the motion passes. Thank you, Dr. Ganem. And we will proceed on to the second case. Second case is Dr., and I'm going to mess up this pronunciation. I believe it's Cabret Karyati Michelle Lin, case number 503213360.
Good afternoon, board. Shane Eldner again, obviously. A hearing on the merits was convened July 24th, 25th, 2023.
1 second, Shane. Is 1 second. One
yeah,
second.
Is Dr.
Okay.
Cabret Carlotti on? You see one hand raised.
Give me one moment. You still have
Jeff.
mic. and camera abilities now.
All right. Doctor, are you there? Jeff, are you able to see who has their hand raised? It is her. Okay. You're still muted, Doctor. Doctor, we want to make sure that we can hear you and you can hear us before we get started. Like maybe your hand is still raised.
Yes, both individuals that have their hand raised, you both have microphone and camera abilities now. You will need to unmute your mic in order for us to hear you.
Something wrong, we can do it. No, it's okay. That's right.
Is counsel on for Dr. Is it Cabre Carlotti? Well, and again, I keep seeing a hand come up, but obviously we're not hearing you guys yet. Alicia, can you and staff kind of get with them on the side and try to contact them and make sure that we can hear them? And in the interest of time, I'd recommend we just move ahead to some of these other agenda items that are brief, and then we can come back to it as soon as they're able to communicate with us.
Okay. All right. All right, agenda item number 15 is the executive director report. So, Mr. Carlton.
Okay. Yeah, and I know there's a lot of people here that have a lot of stuff they'd like to say, so I don't want to keep people waiting any longer than they have to. And in the interest of time, I'll also keep my update brief. Joey, are you on for the budget update? Maybe. All right. Joey may be joining us here in a second. For the rule update, okay, so separate from the rule that's being discussed today, as the board is aware, we've been going through a full review of all of our rules. It has been, I believe it's 25 total chapters of rules. It is a lot. We've been working on this for over a year. All of the chapters have been gone through the kind of the initial process for review through staff and the other rule revision process. So what you can expect to see as board members is in time for the June board meeting, all of those rules will be available for you guys to start reviewing and considering. We'd like to maybe put them up a little bit early for you guys that you can access them before then, since they're pretty extensive for all of them. But you guys can start looking at that and seeing the suggested changes to the rules to update them, bring them a little bit more in the current times. A lot of these rules were written many years ago and they're in serious need of updating. So in the June board meeting, there will be quite a long list of rules. It will go through a similar overall rulemaking process as the rule that everyone is interested in today. So it will, if the board adopts the language, it will then go out for public comment. It'll be put into the register. Everyone will be able to see what the suggested changes are, and then start submitting any written comments on those. And so Potentially, the board after that, the June board meeting, the next time the board could even consider the rules would be during the August board meeting, but probably sometime in August or October. Our expectation is that all of the existing rules will be updated and published and be final. Obviously, this one that we're talking about today is separate from that as far as the list we're talking about specifically. That one may take a little bit longer, but we'll get into that a little bit later. So I think, Joey, hello. You appeared while I was looking back and forth. So we'll go with the budget update.
Of course. Thank you, Brent. Good morning, board members. So I'll be brief. Snapshot of what I mentioned yesterday in the Finance Committee. The agency's revenue collections through the end of February are currently over $19 million. That's about $1.5 million more than what we collected last year. We've also met our statutory requirement to collect sufficient revenues to support our expenditures through the end of the fiscal year. So excited about that. Our current budget execution is at 98.5%, and we do have plans to spend the rest of that money by the end of the fiscal year. Real quick, we are in the process of going through the exercise for the legislative process. I've met with the leadership team, so we'll have more information for y'all in the June board meeting, and then we'll get that document submitted probably at the end of July, and we'll have the final presentation of what got submitted in August. And then finally, an update on FTEs. Of the 35.5 new FTEs that were authorized, 30 of those positions are filled, so we're excited about that. And so far, our FTE count is looking great for the rest of the fiscal year. Pending any questions, I'll hand it back to you, Brent.
Joy, the extra $1.5 million we were able to collect, do we get to keep that?
We get to keep 60% of that.
60% of it. If it gets allocated to us in the next session. Yeah.
Correct.
Okay. Does the board have any questions for Joey? No? All right. Thank you. Again, keeping my update brief, I think that will complete it for me unless you guys have any questions for me. No?
All right. Thank you, Mr. Carlton. Do we have them here yet?
So I believe Mr. Rivas and Dr. Carletti are in the meeting. So Mr. Rivas, if you can hear us, you will need to turn on your microphone and turn on your camera.
I can see a hand raising, but not hearing anyone yet. All right, I'll give you a few more seconds to say something. We'll move on to another item and then come back again.
All right. So with that, Dr. Brett, do you want to go ahead and give the medical director report?
Yes. Good morning, everyone. Thank you for being here. And I do want to thank you for the recent process changes that you've made in some of the expert report reviews. We've done a great deal of progress on getting caught up with the backlog. We currently only have two specialties in which we could use your help for suggestions of expert panelists. One is with oncology and hematology. That's been a perennial need that we've had. And secondly, we have a very specific request for pediatric gastroenterologists. We have some cases that require that specific specialty. So if you have any recommendations for experts in either of those fields, please pass them on to me and I will follow up with them. But I'll go ahead and keep it brief and leave it at that.
Thank you, Dr. Brett. And with the changes in our reimbursement for our expert panelists, have we been able to get more folks on board?
Yes, we've been able to recruit additional experts for that. We're doing very, very well. We actually don't need additional experts at this time outside of those two specialties. And that's really the first time I've been able to avoid just putting out a general call for experts.
Great. Thank you, Dr. Brett. All right, Ms. Sloan, public information update.
Yeah. Good morning, everyone. Just a really quick thing for you all. One thing, really. Right now, our kind of biennial customer service survey is going on. This is something that we're required to do every year as part of the strategic planning process, which, as you guys, if you're familiar with the process, it's kind of the first step of the budget planning process and the entry into the next legislative session. So that's live on our website. Folks who sign up to receive our notifications would have already received a direct invite to participate, but if you didn't, you can see it on our homepage. That's going to be running through April, so there's still time to participate if you haven't, or you have colleagues. And of course, members of the public are always welcome to log in and submit their comments as well. We're going to have reminders about it in the next TMB bulletin, which should come out at the beginning of next month. And then we will also have information on CE Broker that Dr. Zafran mentioned in his report earlier. But that's all I have for you today.
Thank you, Ms. Sloan. Appreciate it. Is Dr. Rowan here for a physician assistant liaison report?
Yeah, this is Dr. Rowan. There are no issues or concerns to report from the PA board.
Okay, thank you. And I'm going to look to you to let me know if they're.
Yeah, they're still able to get in. We're just not able to hear them. We may end up just doing kind of what we had to do yesterday with a phone and the microphone. If we can get someone on staff to give them a call, and that way we can get back to that one and keep moving along. But for now, I think we can go to Mr. Freshour.
Okay, just give me a signal. All right, consideration and possible action regarding pending litigation. Mr. Freshour?
Yes, and good morning, board. I'm going to be much like Dr. Breton and Ms. Sloan, very short, sweet report, so to speak. There's a few appeals going up through, and those are your normal substantial evidence appeals where you've entered a board order and the physician or the licensee disagrees with it, and they've gone to state district court. Again, we've been prevailing on those for the most part with the Attorney General's office. We do have a couple of cases, one right now that is going up to the Supreme Court, and they've asked for some briefing on it. But again, that is a case you did a number of years ago, and it's working through the system. We're not sure where that will end up yet. When we know something further after the briefing, I will give you an update on that particular case. Otherwise, as I said, not anything really to report, just usual stuff going through. Ted Ross is our primary attorney at the Attorney General's office, and he's been doing a great job, and we've been prevailing, and your decisions have been affirmed across the board with the court in most cases. So doing very well in that perspective, and if there's any questions, I'll be glad to answer them.
Thank you, Scott, as always.
Right, thank you.
We have just some reports that are here. Obviously, there's no need to vote on those. Report on suspensions of operation by operation of law. Report on cease and desist orders approved by the executive director. Report on automatic orders. Those are primarily a lot of other rules, as Mr. Carlton has indicated, that are not going to be considered until the next meeting. With that, I'm going to kind of hold for a second and see if we have our other licensee here.
It looks like they're trying to call over there. Do we want to, let's see, Scott and General Counsel team, is the consent agenda ready?
I believe it is, Mr. Carlton. I know that licensure minutes are ready. I think the last board meeting is ready. Ms. Tuthiller, Ms. Yarbrough, DPRC, I believe is ready to go. Is that correct?
Yes, those are in there.
Okay, yes, Ms. Carlton, I do believe that the consent agenda is ready to go. As Ms. Unterborn can, or Ms. Jack, I guess, and Ms. Nordstrom, our licensure minutes are ready also, correct?
Okay, well, with that, then I'll go ahead and move on to the consent agenda.
Yeah, we can do the consent agenda.
Okay, so the first item on the consent agenda is consideration and approval of the December 8th, 2023 Medical Board meeting minutes and action items. Is there a motion on that?
Vanderwide, move to approve.
Motion and seconded. Is there any discussion? All those in favor, please say aye.
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 All those opposed? All right, that motion
I'm sorry,
passes.
who did the second? It was not captured on the record.
Dr. Nyack.
Nyack.
Okay, thank you. Can y'all please turn your microphones on just that way we can make sure that the audio is captured? Thank you.
All right, the second item on the agenda is committee reports and the consideration, approval of minutes and action items of committees meeting during the board meeting. Is there a motion on that item?
Motion, Harrod.
Second,
Motion by
Morgan.
Harris, seconded by Ms. Morgan. Is there any discussion on that? All those in favor, please say aye.
Aye.
All those opposed? All right, motion passes. So we're going to go ahead and just wait until we can get our second licensee on because the next item on the agenda. Okay, because the next item on the agenda is going to be the rulemaking process. So with that, let us go to the PFD.
And just to clarify for the purpose of the audio, as you said, it's reports or agenda items number 20 through 24. I'm sorry, 25. And there are no items for 26 and 27. And items 29 through 35, there was also nothing to consider for today. So that leaves us now with completing agenda item number 14, agenda item number 28. There's nothing for agenda item number 37. So we need to complete 14, 28, 36, and 38 for housekeeping purposes. Ready?
Sorry, I've got Mr. Rivas on the phone, and Dr. Carlotti should be in the meeting and able to turn on her audio. So,
okay.
All right. Mr. Rivas, can you hear me? Okay. Are we?
I'll hold it up as close to the mic as you can.
Okay.
Yeah. All right. Okay, yeah, thank you guys. Sorry for any technical difficulties you were having. We did want to make sure you're here because it's an important part of the process. If you were able to see before, each side is going to have 10 minutes to make their presentation to the board. Board staff will go first and can reserve any time they have left over. And Ms. Carlotti, you and your counsel will go second. So with that, Shane, you may proceed.
Okay, thank you, sir. Good morning, board. Shane Eldon with Litigation Division. A hearing on the merits was held in this matter against respondent, and July 24th to 25th, 2023. PFD came out November 16th, 2023, in which the ALJ found no violations of the Medical Practice Act. As a result, board staff would recommend that the case be dismissed and that the board adopt the final order that's been presented to them.
Okay.
All right, counsel? Or Dr.
Your Honor,
you have to
we
respond?
concur with.
Okay.
All right.
Shane,
Shane, do you have any rebuttal?
follow-up?
I didn't hear what Mr. Rivas said.
They just said that they agree with you.
Yeah.
I'd like to hear that. No rebuttal.
Okay.
I know it's straightforward, but I want to make sure we have everybody on for this.
So with that, is there any questions or discussion by the board? Do we need to go into executive session or have a long deliberation? Okay, is there a motion?
I have a motion.
Dr. Vanderweide.
I move that the board adopt the findings of fact and conclusions of law of the administrative law judge and the proposal for decision and approve the suggested final order filed in this matter by board staff.
Second.
Motion's been made and seconded by Ms. Barnes. Is there any discussion on the motion? All those in favor, please say aye.
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 All those opposed?
Nay.
Okay.
All right, so we have 2 nays. All else ayes, so the motion passes. All right, that's it.
All right. Again, so now we're going to go into agenda item number 28.
All right, so the way we're going to handle this is, and I'm speaking to the board members here, is that we have a proposed rule around describing exceptions for abortion. I'm sorry, I'm just kind of pulling this up here. Okay, so to kind of lay out how this whole process has worked, there is a law that is passed, or that has been passed. There have been questions that were asked around certain processes or how exceptions are defined. And that question came up in a court ruling also, which ended up going to the Texas Supreme Court. And the Texas Supreme Court gave some suggestions that the medical board can give guidance on this issue. Initially, of course, as there were a lot of pending litigation going on out there, we needed to hold off on doing anything until we got some direction from our counsel as to what we can or what we cannot do from that standpoint. In the meantime, there was a petition that was entered for a rule, that was made for a rule. And by law, when a petition is made, the board has 60 days to consider the petition for rulemaking. And with that, we are able to look at all the legal factors that are around it and make a decision as to whether we will or we will not adopt a rule. The decision was made that we would put a rule for consideration to the board and that we would discuss it here today. And based on that, make a recommendation on whether we approve it as is or with modifications or to not approve it. When or if it gets approved, it would go out for public comment. That public comment would last a period of 30 days. As the board would meet afterwards, we would take all those public comments into consideration, and we can either modify the original board rule as it was adopted for consideration, or we could make substantive changes. If substantive changes are made, again based on additional input, then it would have to actually go out for additional public comment. If there are no substantive changes that are made, the board rule at that point could potentially be adopted and finalized. So this process, at a minimum, would take until the next board meeting. But depending on how we decide to change things at the next board meeting, it potentially could go on to another board meeting after that. So in general, that's how the process works. I think there's a couple of things that I had mentioned earlier on as far as considerations that we did as far as the rule is before I actually read it out. Number one, as I had mentioned before, because there was pending litigation around the issue, the Attorney General's office was consulted on this issue prior to the rule language considered. This does not mean that they agree or don't agree with it, but they have seen the rule, they understand it, they have seen it, and they've been able to weigh in and make suggestions as they are also represent us as a board when there are other issues that are out there. Additionally, speaking from that standpoint, I had mentioned earlier on, but not all of you may have been here, but there is language that came specifically from the Supreme Court that I think it's important for all our licensees to know, but more importantly for the public to know. And again, specifically, and I'll read out the language from the Supreme Court language itself. It says, a woman who meets the medical necessity exception need not seek a court order to obtain an abortion. Under the law, it is a doctor who must decide that a woman is suffering from a life-threatening condition during a pregnancy. Raising the necessity for an abortion to save her life or to prevent impairment of a major bodily function, the law leaves to physicians, not judges, both the discretion and the responsibility to exercise their reasonable medical judgment given the unique facts and circumstances of each patient. I would remind everyone that this is directly language from the Supreme Court ruling itself. So as we talk about the language of the rule, I just want to make sure that those 2 points are clear and that they're out there. And as I said earlier, the medical board will issue a press release that goes into a little bit more detail on our consideration and the process itself. So with that, typically we don't necessarily read proposed rules in detail line by line, but in this case I will. And then I will move it to deliberations between the board members after that. So this is Chapter 165, Medical Records, Subchapter B, Exceptions to Abortion Ban. 165.7, Definitions. The following words and terms, when used in this subchapter, shall have the following meanings. Abortion means the act of using or prescribing an instrument, a drug, a medicine, or any other substance, device, or means with the intent to cause the death of an unborn child of a woman known to be pregnant. The term does not include birth control devices or oral contraceptives. An act is not an abortion if the act is done with the intent to A, save the life or preserve the health of an unborn child, B, remove a dead unborn child whose death was caused by spontaneous abortion, or C, remove an ectopic pregnancy. The definition is found at Chapter 25, Section 245.0021 of the Texas Health and Safety Code. Ectopic pregnancy means the implantation of a fertilized egg or embryo outside the uterus. And removing an ectopic pregnancy is not an abortion. This definition is found at Chapter 245, Section 245.0024A of the Texas Health and Safety Code. 3. Reasonable medical judgment means medical judgment made by a reasonably prudent physician knowledgeable about a case and the treatment possibilities for the medical conditions involved. This definition is found at Chapter 170A, Section 170A.0014 of the Health and Safety Code. Medical emergency, number 4, means a life-threatening physical condition aggravated by, caused by, or arising from a pregnancy that, as certified by a physician, places the woman in danger of death or a serious risk of substantial impairment of a major bodily function unless an abortion is performed. This definition is found at Chapter 171, Section 171.0023 of the Texas Health and Safety Code. Number 5. Major bodily function includes, but is not limited to, functions of the immune system, normal cell growth, digestive, bowel, bladder, neurological, brain, respiratory, circulatory, endocrine, and reproductive functions. This definition is found at Chapter 21, Section 21.00211A of the Texas Labor Code. 165.8, abortion ban exception performances and documentation. And I believe this is the second part of the rule. A, an abortion shall not be performed in this state unless it is performed in compliance with all provisions of Texas Health and Safety Code Chapters 170, 170A, and 171, in addition to any other applicable federal and state statutes, rules, and court opinions. B, in addition to the requirements above, the physician must specifically document in the patient's medical record, 1, that the abortion is performed in response to a medical emergency. A, underneath 1, that places the woman in danger of death unless the abortion is performed or induced, or B, to prevent a serious risk of substantial impairment of a major bodily function of the patient unless the abortion is performed or induced. Number 2, the major bodily function or functions at serious risk of substantial impairment. 3, what placed the woman in danger of death or what was the serious risk of substantial impairment. 4, how the danger of death or serious risk was determined. 5, how the decision was made to proceed with an abortion based on reasonable medical judgment, including A, what diagnostic imaging, test results, medical literature, second opinions, and or medical ethics committees that were used or consulted, and B, what alternative treatments were attempted and failed or were ruled out. Number 6, how determination was made that performing a procedure in such a way as to give the child the best opportunity to survive would create a greater risk to the woman. And 7, whether there was adequate time to transfer the patient by any means available to a facility or physician with a higher level of care or expertise to avoid performing an abortion. The third section, 165.9, complaints regarding abortions performed. A, the Texas Medical Board will review complaints and perform investigations regarding abortions using the board's standard complaint process. B, if a complaint is determined to be jurisdictional to the board will use independent expert physicians as provided in Texas Occupations Code, Section 154.0561, to review the available information, including the patient's medical record. C, any decision by the board to either dismiss the complaint or discipline the physician who is the subject of a complaint is separate and independent of any other possible criminal or civil action under the law. If the board is aware the licensee is subject to a pending criminal or civil action, then the board may defer or delay action. Depending on the outcome of criminal or civil action, Texas Medical Board retains the authority to investigate and potentially take disciplinary action. That is the text of the rule. I'm now going to open it up to the board members to ask questions and to deliberate between us as board members.
I have a question.
Dr. Quinones.
In section 165.7 under definitions, item 1, abortion, item B, remove a dead unborn child whose death was caused by spontaneous abortion. Should that not be spontaneous fetal demise?
The specific language is coming directly from Chapter 245.
Okay.
So that's how the statute is worded.
Okay.
And again, for clarification, these definitions were put in here because some of them were things that people would come to the board and ask some questions about. Well, what about an ectopic pregnancy? What about, if the fetus has already expired? What is reasonable medical judgment? What isn't a medical emergency? What is a major bodily function? And so we try to put all that stuff together in one place to make it easier for people to see and to make it clear that this is what the board will be looking at as far as definitions for those terms.
Okay.
One other thing that I will just go ahead and state here, and I understand that there was a desire to have a list of potential conditions that would fall under these definitions. We've had this experience somewhat with COVID, where we were looking at conditions that would meet the criteria for not allowing elective surgeries. And it was very difficult for us to go down that path. We actually put out FAQs at the time, but we also still, in spite of that, we're getting a lot of questions about different circumstances out there that frankly we could not anticipate or really get into the minutia of every single case. The reason it's difficult to actually adjudicate that is because you can have a very similar condition, but depending on the other circumstances that are going on with that case, and that's why we have expert panelists that look at that, medical judgment is really not whittled down to a list of conditions. You're really looking at the totality of an issue that goes beyond a specific circumstance. I understand it may be easy that, you may have a chromosomal abnormality. We can list a couple of things here and there. But when you do that, it becomes difficult to go into what may not have been listed. So if this specific one wasn't listed, does that mean that that's not qualified? You have to go back and actually redo all the rules again. Did you not anticipate this one specific circumstance? Things may change as far as what medicine can do to save a baby's life. So a condition that may apply now may not necessarily apply later on. And as the Supreme Court ruling said, it really defers to medical judgment based on what the standard of care is out there in the community based on specific and certain conditions. And as such, you can't put a list out there that defines what medical judgment may or may not be with every single circumstance that's out there, because not every circumstance is exactly the same. You can have two conditions, but two very different circumstances, including where it may have happened. Was it in an area where you could not transfer the mother to an area of higher level of care? And that was actually included in the rules as to whether that was possible or not, which of course would have to be very specifically documented. So given that kind of circumstance, you can have a condition that would be potentially looked at one way in one scenario, but the exact same condition in a different scenario looked at in a different way. And you actually cause more harm by listing conditions without understanding the nuances. You restrict what our expert panelists would be able to do and what they would potentially be able to determine without looking at all those specific circumstances. So from that standpoint, restating definitions that are already in the statutes, and explaining what the process of how we would deal with a complaint, which primarily is, again, going to our expert panelists, which, as you may have heard earlier on, are physicians out in the community or experts in the specific field who can look at a case in an exhaustive way, look at all the circumstances, look at the medical records, look at the documentation, look at the nuances, look at the mitigating factors, and come up with a recommendation to the medical board. And the way that process works is that we have two expert panelists that are typically looking at it. If they are unanimous in their recommendation from the standpoint of standard of care, it comes directly to the medical board that way, whether it's unanimous in saying that the standard of care was met or whether it was unanimous in saying that the standard of care was not met. If the two of them disagree, it goes to a third expert panelist that goes into a lot of detail as to what their recommendation would be. And at the end of the day, again, it comes to the medical board as a whole. We hear it as a whole, and we can opine on it. Even when we make a determination if something was followed as we think it should have or not, even that can be appealed and go to SOA, which is the State Office of Administrative Hearings, as you have seen earlier today with those two proposals for decision. When it goes to a SOA hearing, it goes to an administrative law judge that looks at the findings of fact. In those instances, both sides can actually provide more evidence. There's discovery. It's a full-blown court process hearing. The PFD, proposal for decision that is given by that judge, comes back to the medical board, and we as a medical board are confined by the findings of fact that the judge has determined. And again, that is based on expert panelists, expert witnesses, that was heard on both sides. And from that standpoint, we are able to look at those specific findings of fact, and we can make a judgment specifically based on those findings of fact. We can't change the findings of fact, but we may or may not have discretion depending on what that is. As I said earlier, if it's a felony conviction, for example, we don't have discretion. But in other instances, we have discretion. There may be instances where we would have to refer it to law enforcement. There may be instances where it may involve an institution and we refer it to another state agency if it's not involving specifically a physician or if it's involving another licensee. For example, if it's a nurse practitioner, it may involve the nursing board. If it's a physician assistant who are operating under prescriptive authority, it would fall under the medical board because physician assistants are under the medical board. So again, just kind of going back to that whole overall process is that giving an exhaustive list, we felt, again, this is up for debate. I'm sure we're going to hear a lot of comments as public comment comes out in the next 30 days. And this is something that we will look at and we will debate again, and we can deliberate on and we can make a decision. But that is the overall arching theme from our standpoint as to why we were very hesitant into putting an exhaustive list out there, that in fact it would hinder the ability of specific circumstances to be looked at in a way that would be fair to both parties. Brent.
Yeah, and to expand on that a little more, when it comes to taking our cues from the Supreme Court opinion in the Cox case, again, as you read out about, it doesn't take a court order to do one of these procedures, and it's left up to the judgment of a physician. And then also the court in their footnote talking about how the board put out some guidance when it came to elective and non-elective procedures during the COVID pandemic. So we took both of those cues, and that's kind of also what helped model what we have here as far as a rule. It talks about it is the physician's decision, and if the physician is going to do this, these are the things that need to be documented. And just like in COVID, we did not put out an exhaustive list to say these type of procedures are elective and these are non-elective. It was up to the physician to make that call. Just be sure and document why you did what you did in that circumstance. And so that's, again, what you're seeing here.
And of course, we defined what that process is as far as a physician looking at the different issues that are out there. And again, it's about documenting the Cox case very specifically, really centered around a documentation issue. And this really highlights to our own physicians that it's extremely important to, number one, make that judgment based on the criteria that we've laid out, based on the definitions that we've laid out that are coming specifically from statute, and making a judgment based on that. Frankly speaking, our belief as a board is that anything that goes beyond that is outside of our jurisdiction, that for us to opine beyond those certain set of circumstances as defined by law would really have to be something that would be addressed by the legislature. We can only do so much. We can define what the process is. We can put definitions out there as far as medical emergencies and other nuances that are out there. We can describe what the process is that we go through when somebody raises a question as to what that looks like. But we can't define things like rape and incest being a certain condition. That is not under our jurisdiction. We can't go into very specific circumstances that are not listed in these definitions or that are not specifically listed in law. The only way that that can be dealt with, one way or the other, is by legislative action. We as an executive agency, as part of the executive branch, our ability to do anything is to enforce the law as it's written. We do have some discretion as to help define what the law says, and help to expand on how the process works, but we do not have discretion in rewriting the law or changing certain provisions of the law. That has to be a legislative action. So with that, any other questions from the board members? Any suggestions for, or any questions about certain language? Any suggestions for changes? Okay, if there isn't any, is there a motion out there?
I'll make a motion.
Dr. Bhatia?
Motion to accept subchapter B, exceptions to abortion ban as
Excuse me, Doctor.
I'm going to say as elaborated by Dr. Zaffron just now.
Okay, there's been a motion made by Dr. Bhatia. It's been seconded by Mr. Kokonos.
And
Is there
Dr.
any
Zaffron,
discussion?
Dr.
Yes, Mr.
Zaffron, let me jump in and clarify. Dr. Bhatia, your motion is to publish the rule in the Texas Register as was read out and proposed by Dr. Zaffron. That's what you want to do, right? Is to publish it in the Register for the comment period.
For the comments to arrive. Yes, that's correct.
All right, thank you.
Yes, to make that clear, we are not adopting a rule. We are publishing a rule for comment. And then if there's going to be consideration of adopting a rule, it would be based on deliberation at the next meeting, as I mentioned earlier, after looking at the public comments, deciding if there's going to be any changes. If it's substantive changes, then it would need to go out for public comment again. So you've heard the motion from Dr. Bhatia. There's been a second by Mr. Kokonos. Is there any further discussion? Ms. Morgan.
Clarification. So this is out for public comment for how long?
30 days. The public comment is for 30 days.
Okay.
The minimum of 30 days.
Okay.
So it can be actually up to the next board meeting.
Yeah.
Yeah.
And
It's a
in
minimum.
the registry for public comments.
It will go out to the registry
Yeah.
as soon as they put it out into the public registry, which I think is fairly soon. And then when it's out in the public registry, it will be out there for public comment no less than 30 days. We meet again in June, which is more than 30 days. So at that point, it could be worth 90 days worth of public comments. But that is the soonest that we will deliberate it, unless for some unforeseen reason we decide to have an emergency board meeting exactly 30 days from now. I can almost assure you that won't happen. But it will be at the next board meeting that we would further consider this proposed rule. Right? Any other questions?
And Dr. Zaffron, just so the board members are clear, and Mr. Carlton, I think you hit on that. Yes, Ms. Morgan, the law requires that it be put in the Texas Register. It is a minimum of 30 days. It can be extended, as Dr. Zaffron said. There is also the potential, and I think Dr. Zaffron, you mentioned this morning, and I think it's important that there's the potential for a stakeholder meeting. I think we're planning at least one to be sure we get input. Then the process goes, as you said, Dr. Zaffron. We as board staff will assemble the comments. We'll look at those. If there's anything that may need to be changed, modified, it will be brought back to you as a board. So there's a number of steps that will occur between now and the next board meeting if we get there, including, as I said, the stakeholder meeting. The other thing is, and Mr. Carlton, you may want to talk to the individuals that are at the meeting, that we have also, will have a link on our website if the rule is in fact adopted with the pending motion. It's going to be on our website. There's going to be a link with a comment form to facilitate your comments that you can go on and click and fill it out for the board. So those will be assembled for my staff and my office along with the board. literally almost automatically because we've got the form there. So we may want to cover that in a bit.
Yeah, absolutely. That is something I was going to cover before we begin the public comment portion of it.
Yep. Brent, can you just please help explain to everybody how we're going to announce the stakeholder meeting? Yeah, like we said, there's going to be at least one. Again, depending on how that goes, there may be additional ones, but that will certainly be announced.
Do you want me to cover that now or
Yes,
do
go
the
ahead and
motion?
cover it now.
Okay. So stakeholder meetings are an opportunity to have kind of like we're doing here. It can be in person and hybrid and virtual also, and have individuals take that opportunity to provide comments to the board and to board staff. We will have at least one of those. We may have more than one, depending on the amount of comments we get and requests that we get for stakeholder meetings. Obviously, we want to get as much input as we can from the public on it. Whenever it comes time for doing comments, it really is most beneficial to the board when those comments are submitted in writing. It's also okay if you want to appear and kind of read through your comments that you're presenting in writing. And then there could be an opportunity for a back and forth, not in this forum for this meeting because it's a public comment period that we're going to get to in like a kind of a normal open meeting. But when you have a stakeholder meeting, you have more of an opportunity for a dialogue back and forth to ask questions and get clarification. But again, it is really most helpful for the board if we get the comments in writing, either through the web form that is going to be on our website, and we're going to try to put as much information on our website as possible to help you guys stay informed of where we are in the process and the current information. Again, all that will not hit the website until the board actually votes to adopt publication of the rule. But again, we will have more than one, at least one, probably more than one stakeholder meeting. Again, this may take a while to go through the entire process through the Administrative Procedures Act. The board does have to review every single comment that we get. We need to respond to every comment that we get. So this may take many months, and in all likelihood will probably extend past the June board meeting, possibly into August or even October.
All right, so there's a pending motion out there. Any further discussion? All those in favor, please say aye.
Aye.
Aye. Aye.
All those opposed? Are there any abstentions? All right, the motion to publish the rule passes. All right, so with that, we are going to move into the public comment period. And before we do that, I am going to do something that we don't typically do, which is contingently adjourn the meeting, because I want to make sure that if we don't have a quorum at the end of the public comment period, that we don't get stuck not being able to adjourn the meeting and then end up with a 3-month meeting until June. So
I'll make a motion to
go
adjourn.
ahead, Dr. Batu.
Okay, so again, this is unusual for us. So the motion would be to adjourn the meeting at the conclusion of public comment.
Yeah, we're making that motion now ahead of time, but Dr. Batu, that's your motion.
That's my motion, yes. it
Seconded
is.
by Dr. Quinones. Is there
Second.
any questions? All right, all those in favor, please say aye.
Aye.
All those opposed? All right, so that is passed. So with that, we're going to go to the public comment period. There's a very specific process that we put in place with this. I'm going to kind of hand this off to Mr. Carlton to help with this process and kind of lay out the rules and how we do this. As Mr. Carlton said, this is not really typically a period where it's a debate back and forth between board members and the public. We typically leave that for stakeholder meetings. So there will be other forums for that. But we obviously are very interested in hearing what you have to say. As many of us as possible are going to stay to hear as many of your public comments as possible. I'm going to be here probably at least until 3 o'clock, if all of you are still here until 3. But then I have to leave after that. But we are, you guys are very important to us. Hearing both sides of the issue is extremely important. As we said, this is a very, very emotional issue. There's a lot of nuances to it. We're trying as hard as we can to get it right within the bounds of what we are allowed to do legally. And we're starting the process today, and we'll go from there. So, Mr. Carlson.
Okay, so this is the only item that's left. So as Dr. Zaffron said, we'll be here until public comment is concluded. Just like in any of the, probably several of you, a lot of you have been to the legislature before. You probably will see we were not going to take any breaks once we start this. So if you need to get up and go to the restroom or get something to drink or whatever, you can move around. The board members will do the same, and we'll just keep going through this and listening to the comments. There is a limit to how many people we can have in this room. It probably may have already been explained to you, but there is an overall weight capacity of what the floor can hold. So that's why we can't just have everybody come in and have standing room in the room also. So what we would ask though is in consideration of other individuals that are here and that want to make comments that are not in the room currently, that once you make your public comment, if you would please be considerate of the other people that would like to come and make comments. And if you wouldn't mind trading places with them, kind of in one of the overflow rooms that's in the hallway, and allow them to come in and have the opportunity to make their comments also. One of the other things that we were going to do is there is the sign-up sheet that everybody, I believe, signed up on. Did anybody not sign up? Okay, good. We're going to go through the individuals that are here in person first, and then we'll move on to the individuals that are online. Presumably, not that their time is not important also, but they may not have to deal with issues like parking, and some of them may be in their office or their home or somewhere that is perhaps a little more comfortable than where you are sitting in this room altogether. So that is how we're going to proceed. We're going to go straight down the list here of how you signed in. Everyone is going to get 3 minutes. Obviously, we're going to be pretty strict with the 3 to keep this moving along, again, in consideration of everybody else. So we will go ahead and get started. And first on the list is Steve Bresnan. Obviously, just make sure your mic is on. The green light should be okay. I can't see the.
Is there a green light on there?
All right, great.
We can't hear him.
Okay, I'm sorry. I thought it was on. It wasn't on. Is that better?
Yes, sir. Thank you.
Okay,
great. Good. You don't get to be my age without learning a few things. And one of the things I've learned is that I would appreciate requesting if y'all would allow my co-petitioner, Amy Bresnan, my law partner and wife, to join me. She's second in the list there.
Yes.
And I'd like for her to go first, if you don't mind, because I'll never hear the end of it when I get home.
Absolutely. You may defer to.
Thank you.
To Ms. Bresnan.
Is this on? Can
Just make sure.
Anyway, thank you for your consideration. And by the way, I always open and Steve closes. So thank you for meeting our needs there. First of all, we just want to thank the board for being so courteous and so friendly toward us. We know that this is a difficult situation, and we know that you are not necessarily to blame for it at all, but nonetheless, here we are. So Steve and I believe that nothing is more important than protecting pregnant women and mothers suffering conditions that threaten their lives or a substantial impairment of a major bodily function absent an abortion. And I want to make something very clear, and we've been asked this a lot. We are not representing a client, and at the risk of giving the lobby a good reputation, every now and then we do something out of conviction and not because we're getting paid. We do something because we believe it's the right thing to do, and frankly, more importantly, because we care about our state. Frankly, it's why we're all here. It's why we all came to the capital city to work in and around state government. There's nothing more important to us than Texas. And with that in mind, we are extremely concerned about the current situation. that expectant mothers face here in Texas. And we believe that rulemaking is the right thing to do. But more importantly, the Texas Supreme Court believes that rulemaking is the right thing to do. And for that, y'all are to be commended for taking their advice, which they were not shy about giving in the opinion. And by the way, the good parts of that opinion are on pages 5 through 7, if anybody is interested. As we move forward, we ask that you not let the perfect be the enemy of the good. We also ask that you not make the situation worse. In fairness, the legislature did not know that Dobbs would completely overturn Roe. In fact, most of the legislation had already cleared both houses before the United States Supreme Court even announced it was going to take up Dobbs. And at that time, everyone believed it would just be up to 15 weeks and not at 0, which is where we are today. And I think that's important for people to remember when Steve talks about the passing of this hot button issue from branch of government to branch of government. So it's important to remember how we got here. I want to make this point, and I've made this point in the media. Our petition is nothing short of pro-life. We all know people who are concerned, young families who have expressed anxiety about starting a family under these conditions in Texas. And we all know somebody who under the pre-Dobbs, under the old law, who faced very similar situations to the ones like Kate Cox and other women who were able to be treated not only in the state of Texas, but in their city. They did not have to leave. Today, women have to leave. That is concerning. And I am not talking about elective abortions. I am talking about abortions where there is no choice. The mother will die if she is not treated. And finally, we are extremely sympathetic with the idea of not wanting a list. We go to the legislature all the time and fight lists. Sometimes we're for lists, depending on what the client wants. But we completely understand the apprehension around list. And I do want to emphasize that in our petition, that was a non-exhaustive list, but we nonetheless understand. And finally, and I'm going to turn it over to my husband and law partner, Steve Bresnan. We do once again ask that y'all consider all 5 elements in the Cox case. I know that it sounds like some of them have been codified in the proposed rule. We do encourage y'all to consider all of the 5 elements. And with that, I will close and turn it over to Steve.
I'm just going to say that, we gave you guys a little bit of deference because you're the original petitioners. But in general, let's try to hold to the 3 minutes. Again,
I'm sorry.
I understand you guys are the original petitioners, so I'm going to give you guys a little bit of discretion.
Yes, sir.
But if you multiply that by 100, it's going to be a very long day.
We completely
We're used to
agree
legislative
and
hearings. We know exactly what
Yes.
you're talking about.
Okay.
And I'll try to make up the difference.
All right,
How's
thanks.
that? May I begin?
Yes, go ahead.
I'm used to knowing what I'm talking about when I'm talking about it. I think my friends in the back of the room will attest to that. And since we haven't seen your draft, I'm talking about something that I don't know about, except for what you've had the courtesy to read to us. But I'm not going to use my time complaining about process. I am going to thank you, Mr. Carlson and Mr. Freshour, for the very professional manner in which you treated us in our petition. We're grateful for that, and it speaks well of the board that you've done that, and Dr. Zaffron, you as well. Thank you. We are here. I just want to quote, and I know that Dr. Scott's in the area, so I'm just going to quote out of one of the briefs in the Zorowski case. The following: defendant's expert, Dr. Scott, similarly testified that care is now substandard and doctors in her hospital now refuse to intervene, even as they acknowledge this is not the standard of care because they fear risking a felony or losing my board certification. Not all that's a direct quote from her. That's in the findings of the trial court, I believe. So that's what brought us here. You got people that are scared to death. They're facing death and they're scared to death. And we think that you can do more than it seems that your proposed rule would do. In that sense, we're disappointed. We see some things in there that can help guide medical decision-making. If I have to keep a record of it, I have to think about it. If I have to think about it, I'm making a judgment. I want to make one final comment. Even though you don't feel like you can do something about criminal exposure, that's not right. Reasonable medical judgment means reasonable doubt. A prosecutor must prove a crime beyond a reasonable doubt. If you give physicians sufficient guidance, sir, if you get sufficient guidance from this board and can make a reasonable medical judgment, you will have reasonable doubt when they try to put you in the penitentiary for 99 years. So we look forward to working with you on the process. We'll try to make our comments a little less animated going forward. And we thank you very much again for teeing this up. And for all those other people that'll be involved with us, we expect to see a lot of you. Thank you.
Thank you.
Thank you. And thank you, Dr. Safran. And by the way, congrats on the new digs. This is quite a step up from
Just
the
so
hobby.
that you guys know, this is not really our new digs. The new digs is actually down on the 4th floor.
That's right.
We're just glad to be out of the hobby building. You know? Thank you all.
Thank you.
Okay, I've got, is it Robbie Osley?
I'm going to submit it in writing, please.
Okay, thank you. And Tom Osley, also?
Same.
Okay, thank you. Is it McSary? Sorry if I'm mispronouncing it. Is it Mignon? Oh,
You do not wish to speak.
no? Okay, all right. Raul Lopez? No? Okay. Leah Stewart? Yeah, sure.
Thank you. Hi, my name is Leah Stewart, and I'm with the firm of Reed Clayman, and I'm here on behalf of the Texas Organization for Rural and Community Hospitals, TORCH, as many of you know it. I want to thank the board for publishing rulemaking on this issue. Physicians and hospitals work together to deliver care for Texas patients, and confusion about when reasonable medical judgment permits an abortion under the law is an unnecessary burden in delivering the best possible care. We also appreciate the board's commitment, as you've stated already, to ensuring the rulemaking process includes an opportunity for stakeholders to meet and provide feedback on the proposed rules. Care settings and available resources vary widely across Texas, and the rulemaking needs to provide clarity for that full range of care settings. And so I appreciate your comments earlier on that point. If the rules are not consistent with the legal framework set forth by the Texas Supreme Court or do not address the full range of Texas statutes that create potential criminality or other liability for Texas physicians and healthcare entities, then it might be a step backwards that will possibly result in delays or denials of necessary life-saving care to Texas mothers. So I want to urge you again to conduct rulemaking in a way that allows stakeholders time and opportunity to give meaningful input. Also support your approach of trying to put things that are in the statutes in one place to help cut down on confusion, and hope that there's more opportunity to consider that approach in the rulemaking process. Finally, I'd just like to say that it is appropriate and correct that the decision about whether a woman's medical circumstances warrant an exception to the legal prohibitions is reserved to those who are licensed to practice medicine in the state. And we are confident that a strong rulemaking process overseen by this board could result in a meaningful improvement in the delivery of care from the current state. Thank you so much.
thank you. Is it McCabe? No? Okay. Is it Hogan? Regan? Hogan? No? Okay. Is his last name Crow? I think the initials are CC. It's a little bit harder to read. Yeah, we'll come back to that one. Micah Rodriguez. Okay. Is it Sue?
Yes, thank you, Mr. Chairman, members of the board. I'm Sue Liebel with the Susan B. Anthony Pro-Life America, the nation's largest pro-life organization. Appreciate the opportunity to speak today. We believe that Texas law is clear. Under the state's pro-life protection, doctors can provide pregnant women who experience an emergency with the proper care. We know there are doctors who understand this law because the state's reporting data and statistics show that abortions under the Life of the Mother provision have continued at about the same rate each month since the Dobbs decision. Unfortunately, media misinformation and the medical community's silence has created some confusion, and there have been instances where doctors have lacked clarity, and this is an opportunity for you to provide crystal clear explanation, and we're very glad to see that you're attempting to do so and look forward to reading the rule. We suggest you focus on the following and educate doctors and maintain the policies put in place by Texas's duly elected representatives. You mentioned the legislature earlier. We look forward to spending more in-depth written comments in the 30-day comment period, but we encourage you to consider this. Texas courts have never found the term reasonable medical judgment vague or confusing. Even though it's a standard used in many different types of statutes, the phrase reasonable medical judgment has only appeared in Texas case law 9 times. It's never been questioned as unworkable or too high of a standard. Texas courts have upheld references to reasonably prudent physician or similar types of phrases that apply to the reasonable men standard in the medical context. Excuse me. This too is an objective standard in Texas law. For example, physicians in medical malpractice cases are held to a higher standard, that of a reasonably prudent physician, which takes into account their training and knowledge. And I know I'm not telling you anything that you don't already know. There's an entire chapter of Texas law that governs how expert testimony can establish the necessary standard of care. These standards aren't new, and they apply equally under Texas's pro-life law as under other laws. Doctors face tough situations and must frequently make decisions according to standard of care to save patients' lives. Rather, Texas law prohibits elective abortions. It doesn't stop accepted treatment options for serious pregnancy complications. And there's also no immediacy requirement under Texas law. A doctor can intervene at a diagnosis if there's a foreseeable risk to a woman's life. So the Texas abortion law is not broken. If there are doctors who are confused, the solution isn't to upend standing policy, but rather to educate them that they can use their reasonable medical judgment. For the vast majority of Texas healthcare professionals who were not performing or referring for abortions before June 22nd, 2022, there should be no change to their practice. Thank you for stepping in, though, to protect mothers and their children and women of Texas.
Thank you. Austin Kaplan.
Thank you, Mr. Chairman, members of the board. My name is Austin Kaplan. I'm from Kaplan Law Firm. I'm a Texas lawyer. I represent plaintiffs in the Zarowski and Cox cases, along with co-counsel Molly Duane, Mark Heron, the team at Center for Reproductive Rights, and fellow pro bono partners, the law firm at Morrison and Forster. But today I'm here just in my personal capacity, and like all lawyers, I will be brief. Our legal team will review and submit formal comments, but I fear that the proposed rule does not enough to change the dangerous situation for Texas women and their families. And so we might ask ourselves, under the proposed rules, can Texas doctors finally act when they believe the situation that presents is medically appropriate? Is Texas allowing the best possible health care to pregnant women? Is Texas keeping pace with healthcare in other states? New York, Maryland, you name it. I am sure that we are all here to work to make sure that Texas does not continue to force its own doctors to put pregnant women, to put Texas moms and their families in harm's way. And I'm looking forward to the rulemaking process and hopefully accomplishing that. Thank you.
Thank you. Jonathan Covey.
Mr. Chairman and board members, my name is Jonathan Covey. I serve as the policy director for Texas Values. We're the largest organization in the state of Texas that works on the issues of faith, family, and freedom. We have over 100,000 supporters in all 254 counties. Just wanted to take the time to thank you for considering this issue. And as you know, and Mr. Chairman already mentioned, the Texas Supreme Court's recent decision in the Cox case shows that the regulatory delay is costing more time and more problems and exacerbating litigation efforts on this issue. We believe that every medical provider should know if a woman has a life-threatening condition, she must be treated. Texas law does not stand in the way of a woman receiving treatment. Texas law does not require physicians to turn away a woman with an ectopic pregnancy until rupture. Doctors do indeed have the discretion and responsibility to make such medical judgment calls, looking at the totality of the circumstances. Both of the major laws passed recently, SB 8, the Texas Heartbeat Act, and HB 1280, the Trigger Bill, both expressly provide exemptions from prosecution for life-threatening physical conditions arising from pregnancy. I would mention, and Ms. Sue already mentioned this, but Texas legal precedent has never found the term reasonable medical judgment to be an ambiguous term or to be a confusing term. I know you guys just published this in the Texas Register. We'll be taking a look at the proposed rules in the coming days as well and offering recommendations via public comment period. I do think that I understand your reasons for not making the list. We'll see if the legislature provides additional clarity starting next January, and I highly anticipate that will be the case, especially since the actual language has manifested. But we appreciate the efforts to bring clarity for physicians and for pregnant women. So I just want to thank you for your time.
Thank you. Ingrid.
May I distribute something to the board?
Yes.
Okay. Good morning, board. Thank you for your service to the physicians of Texas and to their patients. I'm Dr. Ingrid Skopp, a board-certified obstetrician gynecologist from San Antonio, where I've been practicing for 30 years. In the wake of the Dobbs decision overturning Roe v. Wade and allowing Texas to implement the Human Life Protection Act, my practice has not changed. Although, like approximately 90% of obstetricians, I do not perform elective abortions, I have always been willing to intervene when a severe pregnancy complication has posed a risk to my patient's life. I understand this law, and I would continue to offer the same intervention to my patients today. Unfortunately, I cannot say the same for my peers. There is abundant documentation that physicians are confused and frightened. In many cases, they have not offered timely intervention. It has resulted in harm to women, including some unfortunate women in this room. These doctors are frightened. They feel that they are making decisions in a vacuum, and that if they make the wrong decision, they can lose their medical license, they could go to jail, and they could incur severe financial penalties. So I applaud you for taking this opportunity to provide guidance, much needed guidance in Texas today. I think what Dr. Zafran has read is a very, very good start, but there are a few other things that we need to be emphasizing. It's been discussed that reasonable medical judgment means what a reasonable practitioner, understanding the details of the case, the actions that they would perform. This is the standard of care. Doctors need to be reassured that they can continue to provide the standard of care in taking care of their patients. It is critical that it be emphasized to physicians that it does not need to be an immediate risk to a woman's life. We know what conditions can cause a risk to a woman's life, but we need to be reassured that we can intervene at the time the diagnosis is made. We do not need to be waiting until a woman is dying. And in fact, it was mentioned the Texas Supreme Court's discussion in the Cox case. They also affirmed immediacy is not required and a woman does not need to be dying. Doctors need to know that. Prior to the confusion, every hospital that I have worked at has had a therapeutic abortion protocol. I assume most hospitals still do. In addition, I would like for you to recommend to the hospitals they update their protocols and they make them known to the physicians so physicians know how to document when they decide to perform an intervention. That way they will feel that they are not making decisions alone, that they have the support of their medical organizations and the support of their hospitals. And I think that will result in much better quality care to the women of Texas. Thank you.
Thank you. But before you leave, I just want to ask, you're a physician, obviously, and I think you brought up a very important point that I just want to highlight. I think physicians make good medical judgment, and I have heard anecdotal incidents where what a physician thought was the right choice to make may have been superseded by what a hospital was concerned about. And obviously, we don't regulate hospitals, but there is a ban on the corporate practice of medicine in the state of Texas. And it's physicians who practice medicine, not hospitals. So I think not necessarily within this rule, but ideas, whether it's for an FAQ or something along those lines to help reinforce that idea. I mean, we can do that because unless we know that there's a situation like that where a hospital, whether it's their legal department or whatever it might be, is superseding what a physician judgment is, it is important for this board to hear that. Because from our standpoint, that's practicing medicine without a license. So again, I just want to highlight that we've heard anecdotal examples of that happening. Maybe it was a little bit earlier on when the law was passed, hopefully a little bit less now. But again, all these rules and the Supreme Court ruling talk about about physician judgment. It doesn't talk about other practitioners or entities, facilities, or what it might be as far as them making that judgment. So,
yes, sir. What you've described is happening. I've seen it as well. And again, I just think doctors need to know that they're supported because they feel like they're alone making these decisions. And that's why we're seeing so much confusion and sometimes bad decision making.
Thank you.
Thank you.
Doctor, one more comment. I'm Dr. Quinones.
Yes, sir.
And I wanted to thank you for taking the time and the courage and your candor and your presentation. I also wanted to comment on something that you said, and that was the idea of reasonable medical judgment. It's a rule that governs our lives as physicians every single day, every single decision we make, every single patient we see. It's not a new concept. It's not a novel concept, and it doesn't change for this particular purpose. I think that going forward, this board feels very strongly that physicians in Texas need to know that they have the support of the board as long as they follow the rules and use reasonable medical judgment and document. So thank you very much for bringing that point up.
Yes, I agree. And I absolutely agree with your decision not to make a list. What we can do is we can look at ACOG's practice bulletins. And in many cases, they tell us the situations that are going to pose a risk. And if they don't, if there's not specific guidance, every hospital has a quality committee that can convene and can give doctors support in making these decisions.
Dr. Badia.
Oh, thank you. Appreciate it. Thank you for your time.
Okay, thank you.
One other thing to point out that you raised, Doctor, is additional language that's in the Supreme Court opinion in the Cox case. And so there, we did go and put, at least as of this point, some definitions that pull from other statutes. But that's why we also wanted to reference in the rule itself to be in compliance with court opinions, because those things can change. But those are things that, while each time something's cited in the court or even in other statutes, it may not be conducive to put it all into one single rule, as those things can change. Those are things that once we do get a final rule, we can put some FAQs and other stuff built around the rule and put some of that language in there, because that way it's not the board that's coming up with it, but the board is putting it in a place where people can find it about, do I need to wait until there's an immediate emergency, and we can cite back to what the Supreme Court says. Yeah.
That immediacy was required. And he was quoting from a different section of Texas statute that didn't even apply to abortion. So that confusion, I think, is the biggest problem, the immediacy problem.
Right.
So thank you for doing that.
Yeah, and as Mr. Carlton said, it's okay. You keep sorry. As Mr. Carlton said, I mean, the rules are very, very prescriptive in how they are adopted. There's a very specific process in how we go about adopting a rule. There are clarifications and nuances that we can easily put into FAQs, and we've done that again going back to COVID. There were emergency rules that were put in place, and there were FAQs and guidances to put in place, because again, there can be nuances there that change very quickly. And if you try to come up with a new rule every single time you want to put those nuances in, it would be a 6-month process just to kind of get that through. So I want everybody to kind of understand that concept is out there, that the rule is something that's very prescriptive, but there's opportunities for other clarifications to be made in other venues that comes as guidance from the medical board.
Okay, right. Thank you. Rebecca Weaver.
Dr. Zafrin and members of the board, thank you for this time to give public comment. My name is Rebecca Weaver, and I serve as the Legislative Director for Texas Right to Life. Thank you for offering and approving these proposed rules to physicians regarding abortions and circumstances described under our current pro-life laws regarding medical emergencies. While our law is clear, implementation has proven problematic since Texas's pre-Roe laws retook effect after the Dobbs decision in June of 2022. This confusion is unnecessary, and we are pleased you have chosen to help clear the confusion. Texas's pro-life laws clearly permit physicians to intervene when a pregnant woman's life or major bodily function is in jeopardy because of her pregnancy. We appreciate your action to clarify this for physicians. Based on your reading of the proposed rule, we're glad to see that the rule restates definitions already in statute, adhering to our current laws, and not weakening the strength of our laws. We also appreciate that you have chosen in the proposed rule not to list out circumstances, but defer to reasonable medical judgment. We do want to make sure these rules emphasize that imminence is not necessary, that women do not need to be at death's door before physicians act, and we'll submit this in writing when the rule is officially published. None of us want pregnant women put unnecessarily at risk when the law is clear about taking action. Thank you for your service to our state, for your time and consideration and for approving release of these proposed rules.
Thank you. Senator Eckhart?
I'm not speaking.
No. Okay. All right. Great.
Thank you.
Yes. Taylor Edwards.
Sorry, I don't know how big I am. Kind of different. All right. Thank you so much for your time today. I am a plaintiff in the Zarowski case, and I kind of have yet to hear something in these rules that would address my situation. I was given a fatal diagnosis at my anatomy scan. Sorry, I need a second. Myself here. I was given a fatal diagnosis at my anatomy scan, a diagnosis that 2 maternal fetal medicine doctors and my OBGYN confirmed that their medical judgment was an abortion. That was the standard of care. They were unable to give me an abortion because they risk life in prison and losing their medical license. No one should have to risk that to give medical care. It shouldn't be something that's even an option. And I also am concerned about what our state government is doing to protect and help mothers and families, and what's being done to address the public health crisis created by the state's abortion ban. I had to flee the state, and to leave the state, I had to navigate a lot of obstacles, including rescheduling appointments several states away. That shouldn't be what's happening to women in Texas. I am currently pregnant today because I got an abortion. I will get to be a mother because I got an abortion. That is something that I think is being missed with all these conversations about lists and unborn babies and all the things. It's just being overlooked that this is real, this is happening, and that this is not a one-off situation. And the last 2 years, our doctors having no guidance on what to do has caused so much suffering. And I really hope this suffering doesn't have to continue.
Thank you.
First of all, I want to commend you for coming out here and speaking, because I think that's very brave, and it's by no means easy to come here and speak about that. Rest assured that we are trying to, within the framework of the law, come up with a mechanism to where those physicians that you said decided that that was what was medically necessary would be able to do so. And that's our intent. So we're hoping, and again, this is preliminary, and I understand that things take time, and that's unfortunate. I wish we could have done this. I wish we could do this right from the get-go. But we are where we are right now. But again, like you stated, you had at least 2 physicians state that this is what was medically necessary. And what we're hoping is that by giving clarification that we are yielding to medical judgment, to reasonable medical judgment, that you should hopefully not get into a scenario like that ever again. So thank you for coming out here.
Thank you for your time.
Travis Edwards.
Hey, thanks for taking the time to talk to us today. I'm Travis Edwards, the husband of Taylor Edwards, who we just heard from. I want to start by saying that there are a few things that I actually agree with you guys on, and that is that you should not be making a list of exceptions, because it's impossible to foresee every possible circumstance and the extenuating circumstances around all of those exceptions. So I agree with that. And I agree that reasonable medical care should be in the hands of the doctors. I think where it starts to fall apart for me a little bit is that the legislative branch of our government has so much control over this situation. As you said, you can only go so far within the bounds of the law as it currently stands. And much of our legislature is not medical doctors, have never practiced medicine. Most of them, have not even spent the time to talk one-on-one with doctors about the situations that they've seen. And so to me, I think that's where we need to kind of take another look at it and say maybe the legislature has gone too far and has overstepped their bounds, and we need to put more power back into the hands of the medical board and of the physicians who are making these decisions. As Taylor stated, there really hasn't been a direct, a direct addressing of the situation that we faced. Much like Kate Cox, we were told to leave the state in order to get the care that we needed. We still see a lot of those same doctors for our current pregnancy that we were seeing before. So we don't feel like it was the fault of the medical staff. We don't feel like the doctors were doing anything malicious towards us or had anything but our best interest in their hearts. So we still trust those doctors. We still see those doctors, and we hope that more doctors can have their medical and professional opinions be the driving force in the decisions that they make with their patients. The decision should be between the family and the doctor, and they should be able to make the best decision for them. A lot of the so-called anecdotal situations that these women have been in and the immediacy argument, I think, to me, it's not anecdotal. I've spoken to those women. I've spoken to their husbands. I've seen the fear that they were put in when they were told that their wife was going to have her life on the line before the doctor could do something. And to me, I don't know how any medical doctor in this room can sit here and say that that's the way that they would want to practice, that they would be forced to delay care until the situation becomes an emergency. That just, I can't imagine many doctors would be okay with that. So I thank you for trying to clarify that and for doing your best. And I hope that we can continue to make progress on this issue. Thank you.
Thank you. Is it Kosh? Cash.
Thank you for having me today. I'm also a plaintiff in the Zarowski case, and I'm here. I'm here because this is very personal to me and to my family. But again, I yet to hear something in these rules that sounds like it will address what happened to me and my family. My child was diagnosed with a host of genetic conditions, one of which was osteogenesis imperfecta, or brittle bones, meaning that if I bent down to pick up my toddler son while I was pregnant with my second child, I would run the risk of breaking his bones. The mental anguish of carrying that pregnancy to term would have killed me. It would not do any bodily harm, as you've listed in your rules, but I probably would have taken my own life to end my child's pain. So I do hope that you will consider the recommendations of a mental health professional in your two-provider rule for reasonable medical judgment. I've heard you say that you don't make the law, but I'm here today because I've tried to get the legislature to act when I lobbied last session and couldn't even get an amendment for fetal anomaly out of committee. I've tried to get the courts to help explain what would happen in my situation as a plaintiff in the Zarowski case, and they said that we needed to wait for you. And now you're saying it's not your responsibility either. So where else am I supposed to go? Again, I want to be very clear. Your ruling did nothing to address fetal anomalies that hundreds of women face. I would have given my life to take away my child's pain like any mother would. Your decision to leave fetal health out of your rule will only leave confusion for providers who are counseling parents who are doing the best they can. This is what abortion bans do. They strip away dignity and autonomy from pregnant people, and they take away our rights to decide what is best for ourselves and our families. In my case, having an abortion was a compassionate parenting decision, but regardless of anyone's need for an abortion, these bans set up pregnant people to feel like criminals, forcing us to beg for empathy from the courts that have now normalized suffering and dehumanization of women and mothers. I am here today because I had an abortion. There was nothing that could have been done to save my child's life, but an abortion saved my life. And it made it so that I could be here today to stand up for the other hundreds of women who face situations like mine. So thank you for hearing my statement.
And again, like I said earlier, thank you for coming and, in a public setting, being able to tell your story like that. I know it was not easy, and so thank you.
Amanda Zarowski.
Hi, thank you for taking the time today and for allowing time for public comment. I was wondering if I could also have my husband come up with me. Is that okay? Okay, he's next on the list. My name is Amanda Zarowski. This is my husband, Josh Zarowski. I am the first named plaintiff in the aforementioned Zarowski versus Texas case, a case in which the Texas Medical Board is a defendant. I am very hopeful that the actions you're taking and that the clarity you're seeking to provide will help physicians understand when they can provide abortions. But I am skeptical. I'm curious to understand more why you're agreeing to address this now, when for years we've been asking for clarification from the legislature, from the courts, and or from you. So I am curious to understand what got us to this point specifically. I'm not a legal expert. I'm not a physician, but it does feel to me like a lot of finger pointing is going on. On the one hand, we have the Supreme Court telling us that this decision is up to you and the clarity should be something that you provide. However, today it sounds like you're saying the opposite and that it's not within your jurisdiction and that the Supreme Court should actually be the ones to make these decisions. So it's very confusing. And I would still like my attorneys to be able to review the full text of the rules, which so far they have not been able to do, because I'm concerned that the rules only repeat the language that already exists from other statutes and rulings. But in addition to repeating existing language, it sounds like it's now potentially going to add further burdens for physicians in acting through these documentation requirements. And to me, that sounds like it would just further delay physicians from providing the healthcare if and when they deem it necessary, sometimes to save a life or to prevent someone from almost dying, which is what happened in my case. Had my physician had to wait any longer, I probably would have died. So I am hopeful. I hope that you will help physicians in this state so that people like me don't have to continue suffering and so that our future families are not forever impacted. Thank you.
Josh.
Yeah, I'd like to thanks for the rule that you guys put out today. I think there's been a word that's been talked about, the word reasonable medical care, that phrase, and that seems to really be the crux of the problem here. And one thing you'll note that the folks in the that want to legislate abortion are very happy that you're falling back on the reasonable medical decision language. And the reason why is because they know there's a person who is not reasonable, who will, and has already shown in the Kate Cox case, will challenge doctors who are making reasonable medical decisions. So if we hold that as the standard, expect that doctors will want to use, and if they do, as soon as they do, they will face enforcement from the state. And as you laid out earlier, will then have to go through a process that could include suspension, a very cumbersome process for these doctors. And you're putting them now in a position where we're right back where we started. They will not want to take action because they're afraid. So the circular logic that's happening here is exactly what put us here in the first place and is going to keep us here. I understand this is a big challenge for you guys, so I'm not saying there's an answer, but there's a very clear problem that I think we just need to be honest with ourselves. This is where we're at. And I'd like to also point out that it is not reasonable for families like what we went through to, and as a hopeful father, to have to take my wife to the hospital myself against any rational, no person should have to ask themselves, can I take my dying wife to the hospital? And we're going to stay in that particular situation if we continue to fall on this reasonable medical decision. Thank you.
Thank you. Yeah. Amy O'Donnell. Yeah.
Does it matter which one you sit in?
Yeah.
No.
And before you start, one thing that I would just make a comment on, we did look at
statute language as we adopted this proposed rule. There may be other language that we may have been able to use or could use if our stakeholders and our commenters pointed it to us. And of course, if it's coming from statute and it helps clarify things even more, we would be very open to that if it is coming out of statute. And I could already see some possibilities out there. So I would encourage those who are putting public comment out there, if you were to look at existing statute and language coming from there that would actually help to add clarity to that and make those suggestions to us, that would be extremely helpful. Sorry, go ahead.
Hi, my name is Amy O'Donnell. I'm the Communications Director for Texas Alliance for Life. And I'm here today to advocate for the board to set forth rules explaining to physicians the meaning of the medical necessity section of the Human Life Protection Act, the law to protect unborn babies from abortion that the legislature passed in 2021 during the 87th regular session. We are grateful the board has taken this up for consideration today. It's important to note as you consider this important issue that Texas abortion laws are saving unborn babies and pregnant women's lives. Induced abortions performed in Texas are required to be reported to the Texas Health and Human Services Commission, and the numbers are recorded on a monthly basis in the Induced Termination of Pregnancy Reports, also known as ITOP. The latest information from the reports, which we have summarized on the attached sheet, page 2 of what I handed you, shows two relevant. First, the law saving unborn babies' lives. Reported elective abortions plummeted from thousands per month to 0 after Dobbs reversed Roe. Second, the law is saving pregnant women's lives. During the first 16 months after Dobbs, from July of 2022 through October of 2023, the latest month of available data, doctors performed 71 abortions, all in hospitals that fell under the medical necessity exception of the law, according to Section 178.002 of the Texas Health and Safety Code, to save pregnant women's lives or prevent risk of loss of a major bodily function. We believe that fertility is a major bodily function. No doctor has been prosecuted by a district attorney, sanctioned by this board, or sued by the Attorney General. No pregnant woman has lost her life for lack of an exception, even with more than 360,000 births in Texas each year. This shows that the exception in the law allows doctors to perform abortions to save pregnant women's lives in those rare and tragic cases when medically necessary. We hope that the rules that you propose will explain that to any physicians who do not already understand Texas law. Thank you.
Let's let the others go, and then we'll back. Okay. Jennifer Allison.
My name is Jennifer Allman, and I'm the Executive Director of the Texas Catholic Conference of Bishops. We would like to thank the board for putting forth the guidance that you have put forth today. We look forward to reviewing it in greater detail. I think perhaps the most important thing you've done is you've provided physicians with a roadmap to understanding the statutes. I think the difficulty and confusion in part is caused by the fact that these definitions are in different chapters and different statutes. And so your rules give a one-stop shop for physicians to know and understand the issue. I also wanted to reiterate that Catholic hospitals throughout the world have been providing emergency medical care and emergency pregnancy complication care without ever providing an abortion for over 100 years. So it certainly can be done. And I think that's important to know as you move forward. I think the definitions, sticking to the statute is really important. So I really appreciate that. Women seeking treatment for high-risk pregnancies or who've lost the pregnancy that they have in the process of losing their unborn children should not have to go through the anguish that we have heard about because their physicians are confused. And so putting forth this information we hope is an important part of the solution. I appreciate that the board has been responsive to the suggestions people have made in looking for ways to further improve upon the start that you've had. I would echo what Dr. Scott talked about in terms of the immediacy or urgency issue. I think that remains a really important issue to more clearly address. And I think it's possible to address it with existing statutes and, as you say, looking around to other portions of the statute. So I thank you for your time and appreciate the fact that you are taking this very important issue so seriously in trying to make sure that you are encouraging doctors and informing doctors on how to provide the best care possible for women and their children. Thank you.
Thank you. Last name Wright.
Good morning, members of the board. My name is Kylene Wright, and I'm the president of Texans for Life, one of the stakeholders who advocated for the Human Life Protection Act, also known as the trigger ban. And while we haven't yet seen your guidance, I was able to listen to your description of it and really appreciate what appears to be a very strong effort to stay true to the statute. So thank you for that. We are grateful for your work to clarify what now seems to be so confusing for doctors. And I say now because these same medical exceptions in the Human Life Protection Act have been in law and in effect for over a decade in Texas, having been included in the state's 20-week ban, which passed in 2013, with no complaints, no sanctions, investigations, or confusion. Even in the months since the law went into effect, dozens of abortions have been performed to protect the mother's life. Clearly, all doctors are not confused. And while the media waxes on about doctors being scared and confused, a closer look reveals a somewhat different story. Take the case of Kate Cox. Mrs. Cox, a Dallas resident, sought help from a longtime abortion care doctor in Houston and ultimately then filed suit in Austin with the Center for Reproductive Rights representing her. Original claims that this pregnancy threatened her life fizzled when she failed to even make that claim in depositions or her appeal to the state Supreme Court. After learning that the primary reason Mrs. Cox sought an abortion was a life-limiting diagnosis for her baby, we also learned that from Texas Monthly's interview of her doctor that the doctor was not at all confused, but rather frustrated that there weren't exceptions in the law for babies with tragic medical diagnoses, for rape and incest, and even depression. In other words, the Planned Parenthood doctor who performed abortions for 14 years wants to continue practicing under Roe v. Wade, which is no longer an option in this state. In the Fort Worth Star-Telegram and other print media covering the longer story, we hear the same thing from different doctors. These doctors are unhappy and frustrated that there aren't more exceptions in the law. Well, there is a process in place for changing laws that we don't like, and it is not in court or at the Texas Medical Board. This effort, coordinated by the Center for Reproductive Rights and Planned Parenthood, is nothing more than a backdoor attempt to do what this board is not legally permitted to do, and that is expand the exceptions to the greatest extent possible at the expense of preborn babies. And I trust and do appreciate that you appear to have clearly seen through this and are making a great effort to stay true to the law. So thank you.
Looks like it's just a first name, Amy. Okay. Ingrid again. It's the last name B-O-N-A? Sure. No. Okay. Dr. Ivy.
Hi, good morning, and thank you for the opportunity to speak. I'm Dr. Richard Todd Ivy. I have practiced obstetrics and gynecology in Houston for over 30 years. I'm speaking here today on behalf of the American College of Obstetricians and Gynecologists, District 11, and the 3,268 practicing obstetrician gynecologists in this Texas section. Collectively, we welcome the opportunity to work on this important issue. As many of you have seen in the news, the language in the current statute has created confusion for our physicians, our hospitals, and our patients. This confusion has led to delays in the provision of appropriate care with increased morbidity, unnecessary suffering, and alterations in people's plans for family. I certainly understand the concept of reasonable medical judgment, but in this area of that's so heavily scrutinized and the penalties are so severe that I think it's appropriate to understand a physician's confusion and hesitation in this arena. As physicians, we believe our patients need unimpeded access to the full spectrum of reproductive health care options. It is absolutely unacceptable for doctors and healthcare professionals to be punished, fined, sued, and face imprisonment for delivering evidence-based care. We recognize that abortion for any reason is a complicated topic. We also recognize that the decision to have an abortion is a very complex one. In all my years of practice, I've never seen someone reach that decision easily. It is for these very reasons that this decision should be left to the patient and their trusted healthcare professional. Doctors and clinicians must be able to provide unbiased, factual information to patients regarding reproductive health care options. And people must be able to use their own judgment in making their healthcare decisions for themselves and their families. With your leadership, we trust that the physician-patient relationship will continue to be respected. We are grateful for the opportunity to review this rule today and will offer thoughtful scientific commentary during the next 30 days. Thank you.
Thank you. Kathy Toro. Not a Kathy Toro. Right, then let's see. Wasn't marked again. You want the initials CC? Go back to any that we didn't respond before we move on to the virtual attendees. Okay, I think is there anyone else that's here that would like to speak that has not already been called on? Great. All right. Is there anyone online with us that would like to speak?
So for this portion, we are going to run a poll within Teams. So you'll see pop up on your screen either a check mark or an X. If you would like to comment in public comment, please check the check mark. If you do not want to comment, you can click the X. For those that have joined us via telephone on call, you may not receive the poll popping up on your screen. So we will address y'all individually after those that are signed in via Teams have had a chance to make public comment. So again, you have a poll pop up on your screen right about now. And please respond with how you would like to comment via public comment. Thank you. Sorry, 1 second. I need to record the names on there.
I'm sorry, Alicia, you said the poll popped up there.
Yes, we have currently 17 responses with all no's so far. We have not received a yes response.
Okay, we'll give it a few more seconds to let people make sure they saw it and respond as they'd like to speak or not. If that is going to be the end of public comment, then we will be at the kind of automatically at the end of the meeting based on the motion to adjourn earlier. So let's give it another few seconds. Go back to the audience again. If anybody has that did not speak yet that would like to. Okay, well, I guess no one else has raised their hand or voted yes that they would like to comment. Dr. Stafford may have some. Oh, sorry.
We do.
Okay.
We do have individuals that are signing up. I only have 23 responses of the 223 individuals that are signed in. So if we can maybe give it a couple more minutes, it may be helpful, or a couple more seconds.
Yeah, we'll give it one more minute to 11:20. I think we're at 11:19 now. Give people an opportunity to look, and then we'll go from there. But while we wait for the results of the poll, again, just want to go ahead and take the opportunity to thank everyone that has made a comment so far. This is helpful for us. Again, it would be we prefer that you do provide some comments in writing once the rule language is posted on the website. Take your time, look it over, really put some good thought into it for us with whatever your suggested changes would be. If there's anything that we should delete, reword, add in, things that are not addressed yet, whatever you can do to kind of put it down in writing will really be helpful for us in being able to analyze it, even more so than just kind of just overall statements of, I think the rule goes too far, or I think it doesn't go far enough, or something. If you can give us something more specific to work on, that would be very helpful.
And as we stated earlier, it's a lot easier for us to consider items that are directly related to existing statutes. I just want to remind everybody that we cannot make law. We can help clarify existing law. So as you put comments in there, being able to tie it into existing statute, then that would help us from that standpoint be able to consider it in a way that keeps everything within a legal framework. So just, again, keep that in mind as you make suggestions to us.
Okay, Alicia, how are we looking now?
I do only have 29 responses. I do have to close the poll in order to see the name of the individual, the person that wants to speak. So I will close the poll now to see who responded yes.
Okay.
The person that responded yes is actually a member of staff. However, I do have a public member with their hand up, so I'm assuming that they'd like to comment. I have allowed their microphone and camera if you'd like to ask their opinion in.
Sure. So, all right, just to clarify, so we have one member of the public that would like to comment and also a member of staff that would like to comment.
They responded yes. I will reach out to them to make sure that they meant to click that.
Okay, great. And let's see, Rachel Gearing, is that right?
That's correct.
Okay, thank you for waiting around. And you have 3 minutes and you may begin.
Thank you so much. I will be quick. My name is Rachel Nelson Gearing. I am a healthcare attorney in the Dallas-Fort Worth area, and I represent several OB-GYN practices and fertility practices. And I first want to say, after discussions with our clients, our firm has put out a lot of guidance and done our best to relay the law to our physician clients as the changes have happened over the last few years. And I will tell you, we do have lots of physicians that are nervous, and I know it's been discussed with other speakers about how they are supposed to interpret the law. I think there's a lot of concern that while there is this reasonableness standard, that this is more of a political fight for our elected officials, and that their reasonable medical judgment will be looked at in a vacuum. And I've heard several speakers dismiss that fact, that, you know, physicians are allowed to be reasonable, and they always have been. But I think speaking with our OB-GYN clients, that they don't feel safe to make, that their reasonable medical judgment will be looked at in a vacuum because this is such a political issue. And for that reason, they are looking to the Texas Medical Board to kind of be bold in its position to protect physicians and to provide additional guidance that will make them feel secure that they can make the decisions that they need to protect their patients. I also want to say it is deeply concerning to hear some of the speakers here today disparage Kate Cox and others that are in the room who have dealt with tragedies with their pregnancies. I can say, not just as a woman and as an attorney, but as someone who works in this space, that those are real situations. And I do think we should refrain from allowing people to, you know, voice opinions that are going to be negative on the physicians involved, as well as the patients, when we're talking about such tragic situations. So I guess I would say I think as much as we understand that the TMB does not get to make law and your job is to interpret and provide guidance, I think we are hoping that the TMB will be bold and provide stronger guidance. As other individuals have said, fetal abnormalities are not addressed. We have physicians that are concerned that their reasonable judgment may not withstand the scrutiny from elected officials that are very, very strongly pro-life, regardless of how the physicians feel about protecting their patients. So I just ask that you all consider strongly increasing the, amending the rules to provide additional guidance for those physicians. And I'll yield the rest of my time. Thank you.
Great, thank you. And can we look forward to any comments you may want to submit on the rule with suggested language to help with the boldness that you've kind of recommended?
Absolutely.
Yeah, in general, one thing I would just like to state, so we talked in our proposed rule about the process as to how we would deal with complaints. We look at all conditions out there that may come to us as a standard of care issue that deals with a certain element of medical judgment. And it's not the medical board that opines on that. We send it to our expert panelists, which are actually physician members of the community. As Dr. Brett spoke earlier about our physician panel, or our expert panelists, these are physicians from around the state who are board certified in that specific specialty that we're addressing. And as we, as a board, get a complaint under any type of standard of care issue, if we feel that there is a jurisdictional issue around standard of care, we send it out to our expert panelists. And those physicians who are experts opine on the given scenario and the given situation. Because as we stated earlier, there are many different circumstances that you cannot list and potentially cover any kind of situation that's out there. As I described earlier, you can have the exact same condition with two different individuals, but the circumstances around it may differ, and an expert panelist that looks at the medical records, looks at the scenario and the situation, may opine differently on those two different situations. Somebody commented earlier, and again, I'm not going to get into the specific comments, but just in general, just as an opportunity to kind of explain things, medical record keeping is not something that we're adding onto in this rule, but we're emphasizing as far as what we expect physicians to do as they describe what their thought process is as they are looking at taking care of a patient. We expect that with any physician under any circumstance. Medical record keeping is that way of telling the story of what is going on in managing a patient's care. And as we all know, diagnosing a patient is not an exact science. It may be the incorrect diagnosis, but the process as how do you arrive to that diagnosis may be exactly the way you're supposed to do it. And we have to look at that. And only the medical record and talking about what that thought process is the only way that we can look at that and see whether that was within the standard of care or not. So medical record keeping is something that is expected in all different types of scenarios and situations. What we're saying in this proposed rule is that it is important in that medical record keeping to explain what the medical reasonable judgment is in that specific type of scenario. And that is what an expert panelist is going to look at as they opine back to the medical board as to whether it met the standard of care or not. Because again, a situation can be in a rural area versus an urban area where there may not have been the ability to transfer a patient to a higher level of care, where the answer may be different, even though the scenario may be exactly the same. So if you put a list out there, that may be a list that is accurate in one setting, but inaccurate in another setting. So just as we talk about this and deliberate it, I just want everybody to understand that this is not an exact science, but we do want to make it a process that is clearly understood, that is clearly defined, as we do with all our other issues around standard of care, that we are going to treat this the same way. The definitions are important to be out there because that's what we're going to lean on as we define what a situation or what a certain scenario is. And those definitions, again, come straight out of statute. The only way we can modify those definitions, the only way we can come up with other definitions is going through the legislative process. We cannot create definitions that are not existing out there. So again, I would encourage everyone who would like to make comments and suggest changes to lean on that, to lean on potential definitions that are out there in statute. Maybe we missed some out there that would help clarify this even more. And that would be something easy for us to look at and to address and see if it's something worth adding into our proposed rule.
Yeah, also, I know it was brought up before too about potentially having to document these things would be a delay in care. I don't believe it's contemplated by the board that someone is in an immediate medical emergency and the physician needs to stop saving the patient and treating them to go and document a bunch of stuff. I mean, this can come after saving the patient's life. So it's meant more of, again, a documentation piece that can come after the procedure has already been performed. And also too, with reasonable medical judgment, I mean, it comes up in discussions among this board all the time, is that doesn't mean that's the decision that every single doctor would have made. Sometimes you can have reasonable option A or B. Both are reasonable. One may have chosen one over the other, but I don't want that to mean that people have to think that reasonableness means that there was only one choice that could have been made. All right. So you'll have a hand raised. Do we have anyone else? Alicia?
Yes, we do have one hand raised. It's come to mine and IT's attention that folks that are outside of the organization may not get the poll popped up on their screen. You can access it via chat, but if you would like to make a comment, please just raise your hand. Next person we did have with their hand raised was Julie Gutierrez. I will make sure to allow your mic and camera now. Julie Gutierrez, you should be able to unmute now, so we'll be able to hear you speak. If you no longer wanted to make a comment, please let us know as well.
Hi, Julie, can you hear us? All right, well, maybe we'll come back to Julie. Some of you may not have been able to, some of you may not have been able to see the poll. Is there anyone else?
We have a Kyle R, and your mic and camera has been allowed. You will need to unmute for us to hear you.
Kyle? You may be on mute. You can unmute yourself and go ahead. I will move on. We'll go back. Julie, are you there? All right, Alicia, anyone besides Julie or Kyle?
No, no one else. Again, in order to raise your hand, there should be a feature at the top of your screen with the little hand icon. For those that are signed in via telephone, I will allow your mic now. You'll just have to kind of start speaking, and please state your name. Oh, if you called in order to unmute, you need to press *6.
All right, Julie, Kyle, or anyone else that *6 on your phone and would like to make a comment. See another hand pop up.
Julie did rejoin us. I allowed your mic and camera again if you want to give it another shot.
Hi, I'm sorry, I don't have a great connection. I'm in the hospital right now. I am a general OBGYN, and I have been practicing under this legislation. And I just wanted to comment that it's really insulting that that Dr. Scott and Ms. O'Donnell, say that we should, these doctors, that's our own fault that we don't know reasonable medical judgment. And I've also was presenting at a national conference, and was basically all of us were called cowards for not stepping up and providing the care that these patients deserve. And it's really a horrible situation to be in, to be a physician and seeing women suffer, and knowing that you're providing substandard care.
Thank you for your comments, Ms. Gutierrez. I'm sorry, Dr. Gutierrez. I would, we at the board would welcome any written comments you may have for us regarding the proposed rule language that might, help give you and other physicians the type of clarity and reassurance that you would like to see in the rule. Kyle? All right, or anybody else that's online? The audience here in the room has drastically dwindled from where we started, but that's good. We got through, I think, everybody that wanted to talk. Not hearing anybody else online or from Kyle. Again, if you can hear us and you're just not able to communicate with us, please do submit your written comments to us based on the rule language and what you'd like to see in it. And we look forward to reviewing that. And I think with that, this meeting is adjourned.
Yeah. Well, again, thank you everyone for being here. This meeting is now adjourned.
It's 11:36.